Committee will come to order, at least for purposes of taking a roll while we try to attract a full complement of members. Clerk, open the roll.
Mr. Chair, you have a quorum.
By the skin of our teeth. All right, I tell you what, while we wait for a couple of members, we'll take up some of the easy, quick bills that first, we've got Senate Bill or House Bill 437 from Delegate Herring. That bill needs to be re-referred to the Committee on Rehabilitation and Social Services. Is there a motion? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? No. 1 to 1. All right, that bill is re-referred. Also, House Bill 1167, Delegate LaRock's bill, needs to be re-referred to the Committee on Privileges and Elections. Is there a motion to that effect? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? That bill is re-referred. We're also going to pass by for the day at the request of the patrons, and we're trying not to do this. We're going to have a limited number of meetings. So this is not an encouragement for anybody else to ask for their bill to be passed by for the day. But Delegate Hope has House Bill 52 and House Bill 88. And Delegate Price has House Bill 1033. So without objection, those bills will go by for the day. We have a number of bills that are identical to Senate bills that passed in the block. First, we've got House Bill, and we can, unless there's an objection to any of these, we'll take these in a block. House Bill 135, Delegate Bell's bill, deals with dissemination of juvenile record information for emergency medical services. You'll remember this is identical to bills by Senator Black, Wexton, and maybe Favola. Senate Bill 109 passed out of the Senate 14-0 out of this committee, and out of the Senate 40-0. Also, House Bill 235 dealing with the acceptability of electronic records for criminal proceedings, identical to Senator Stanley's 180. Likewise passed out unanimously. Then House Bill 743, the judicial number of judges for each judicial district and circuit, identical to my Senate Bill 525.
Mr. Chair.
That I know Senator Deeds wants to record a negative vote to.
I just want to make sure if you're going to pass 743 that it has the amendment that you put on finance in that bill. You added
Mr. Chairman, it does. They're identical now.
Right.
Okay.
Okay. All right. So is there a motion to report those three in a block? All right. Second. Any discussion? All in favor signify by saying aye. Aye. All opposed? And Senator Deeds probably wants to note his. Okay. Huh? All right. At the request of the clerk, open the roll. Yes. We also have one bill. Well, I'll come back to those. We have three House bills with similar Senate bills that passed. They are not identical, but I would expect that at least for two of the three that we would conform to the Senate bill. First, Delegate Collins, House Bill 638. I'm sorry, we're not going to conform that. Is that right? I'll tell you what, let's hold on to that for a second.
Because I stood up, wasn't it?
Yeah, it's exactly. We've got House Bill 1482, Delegate Thomas, which he's got a bill that is similar to Senator Carrico's Senate Bill 508, dealing with the use of unmanned aircraft drones by public bodies, and unless you have any objection, we're going to conform that to Senator Carrico's and report that out. Okay with you?
Perfect. Thank you, Mr. Chairman.
All right. Is there a motion to that effect? Second. It's been moved and seconded. All in favor? Clerk will open the roll. I'm sorry.
That's 11-0.
All right. We also have Delegate Freitas, House Bill 900, dealing with forfeiture of property used in the commission of crimes. Requires a finding of guilt. Senator Peake had Senate Bill 341, which reported out of this committee 15-0, but was re-referred to the Committee on Finance. Is there a motion to do that?
No.
All right, it's been moved and seconded. You want to say anything?
That's
All
good for me,
right.
Mr. Chairman.
Mr. Chair.
Mr. Chair, why don't we
Yeah.
just report the bill?
Yeah, I'm in favor of reporting the bill.
That's my substitute motion, we report the bill.
Yeah, I'm a freedom guy. I'm reporting the bill.
Well, I think this one needs to go to Finance. So, all right, to conform to Senator Peake's and report and re-refer to the Committee on Finance. Is there a motion to that effect? Well, I tell you what, if we're not going to do that, we'll take him up with all the other patrons. So we'll go to the list.
Okay.
All right, Delegate Byron. You want to wait for Senator Stanley? No, there he comes around the corner as we speak. House Bill 998.
Thank you, Mr. Chairman. I know that the other bill that was similar to this that you had in the Senate that I entrusted in the very experienced hands of Senator Stanley had a different
Mistake number
outcome
one.
than what I was hoping for. But
I gave it my best shot, by the way, Mr. Chairman.
I
did
was
a
so
marvelous
pleased to be
job.
able to watch the video because I could see after 3.5 hours and a very busy day, and Senator Stanley was busy, that I just felt like there was a few things that I might want to mention that maybe were not addressed, because I've been in committees that lasted that long.
Yeah,
and
we'll
we're-
give you a couple of
I won't
minutes. Why
take
don't you
too
go
long.
ahead and address the
Thank
bill?
you. So House Bill 998 is a program called Safe Families for Children. If any of you have the opportunity to look at Katie Couric's NBC program that she's been following the last several years, she's done a great job on NBC of showing what this Safe Families program is, and it's nationwide. It's in over 40 states. It's a program that was once an American standard, assistance for those in need from those who are closest to home. It's a community-based program. It relies on volunteers. It doesn't cost the state any money to serve as host families to assist those who are experiencing short-term crises. It's meant to fill a gap in our current system, helping people at the point of before government intervention, before it actually deteriorates to the point where they need to go into foster care. So you'll find that a lot of the letters that we have in support of the stability that this provides for the affected child are most times in neighborhoods that are near where they live, so they're not disrupted from their same schools and the same children they play with. It helps with the overload. It has saved the taxpayers millions of dollars with the what it has saved from the Department of Social Services. Amherst County wrote, I find this program offers tremendous value in preventing child abuse and neglect, as well as adding continued support to families with limited resources. I'm confident this program will positively impact the lives of children and families with whom it has the opportunity to serve. Roanoke would like to see it expanded to the Roanoke area. We have a letter from the Director of Social Services there. We also have a letter from attorneys that said parents can learn proper parenting without the immediate threat of losing their parental rights. There is just comment after comment about how they have provided a structured and stable housing environment for clients that are so desperately needed. This really is a wonderful program that allows parents to still maintain their rights and not be afraid to go and get the help that they need for fear of losing those rights by having to wait until the court steps in and takes their children from them. I do have someone from Patrick Henry Family Services that has worked with children's homes for many years in our region that's traveled to say a few words to you.
Delegate Byron, and for all of the House patrons here, what we have done in hearing these bills is we set a time limit, and it helps everybody for the supporters and opponents of the bill. So if you're ready to turn it over,
Done.
We'll turn it over and let your witnesses speak.
Thank you, Mr. Chairman, members of committee. My name is Patrick Neff. I'm the Director of Safe Families. On behalf of Safe Families nationally and Patrick Henry Family Services, we want to say thank you for the opportunity to do the pilot program for the last 18 months. And in that time, the first 16 months, we had, as Delegate Byron was saying, about 42 hostings. Now, what's amazing is we got an opportunity on the ground to really see how these families were changed. And I want you just to think real quickly, how much would it cost for us to do a state program that helped divert 42 children away from the foster care? Now, I've been a foster parent for a long time. I know what the system costs. And for the state to operate a program that would cost, that would help 42 children and divert them from foster care would literally cost millions of dollars. Here we've done it for free and all through volunteers. Now, the unique thing about those 42 families is that those 42 hostings is that 100% of those children were reunited back to their families. Now, the percentage in DSS is approximately 52%. So about 52% of the children that go into foster care will either remain in foster care or they will be adopted. Now, we know that the importance of children being able to be reunited back to their families. And so we see this program as a great success. It's been better for the children. It's been better for the families. I think it's better for the state. And it really does fill a gap in the amount of children that can be helped.
Mr. Chairman?
Sir Peak.
Could I ask a question?
Yeah, go ahead.
You are operating this through the Patrick Henry Boys and Girls Home out
Patrick Henry Family Services is what it's
of Lynchburg, outside of Lynchburg?
outside of Lynchburg.
How
yes.
long has that organization existed?
That organization's been almost 60 years now.
And, Mr. Chairman, and the purpose of what you are doing is keeping children whose parents are in trouble from going into foster homes?
Correct.
And, Mr. Chairman, and so you were trying on a private basis to keep the families together, the children with their natural parents?
Yes, sir.
And, Mr. Chairman, and so you are working with the parents to get them out of the trouble they are having, is that correct?
Correct. Our
Is
whole
this, and Mr. Chairman, is this in any way interfering with the courts and what they would do or their guardians in the court system?
No, sir.
All right, thank you.
All right.
I wanted to tell
Thank you very much. Yes.
Mr. Chairman, the only question you had asked me is that they do have to have background checks and all the other things that
Tell you
are
what,
required.
let's circle back to you. Anybody else wish to identify yourself and state your support?
Mr. Chairman, Josh Schetzer on behalf of the Family Foundation, and we also support the bill.
All right, thank you. Now, Kathy, here's my concern, and I've tried to prime you, haven't sugarcoated it. Told you what some of the concerns were that were expressed when Senator Stanley's bill came through. And I want to say, it sounds like a marvelous program. It sounds like it worked really well in your part of the state. And with this limited application of it, I am very concerned about opening this up statewide without making sure that we can replicate the controls. It sounds like you partnered with a great private organization, but I don't know how we restrict the private organizations that would participate using statewide application, and that concerns me when we're talking about transferring custody of children by power of attorney.
Did you want me, can I finish?
Sure.
Okay. So the only thing I would say to that is that I would encourage you, if it doesn't go anywhere today, that you continue to monitor this, because in 40 other states it is working. And also, they maintain custody of their children the entire time, and they can withdraw the power of attorney at any moment as well. They have to register with the local Department of Social Services, have the same training as foster parents. So all the checks and balances are in place, and I hope that you will continue to consider this, because it is a great program and it will help families. Thank you.
Thank you. I think somebody wanted to speak in opposition. Step up.
Good afternoon, Mr. Chairman, members of the committee. I'm Richard Garriott, here on behalf of the Virginia Family Law Coalition and also on behalf of the Virginia Commission on the Needs of Children. We've dealt with this bill before, and I know this was before the committee on the Senate side with the bill. And so I would refer you again to the report from the Department of Social Services that was given to you all, saying that there needs to be some more study on this. And I agree that the folks at Patrick Henry are doing a great job. I sat on the board in Virginia Beach of Seton Youth Shelters for many years, a private organization doing much the same thing. The issue here is one of oversight. And the way this bill is drafted currently, while the amendments have helped somewhat, there's still a question on how much oversight there's going to be over a 501c3 corporation who is going to, in essence, be able to place children wherever they want to. And while these groups are doing a wonderful job, we all know there are groups out there that could create a 501c3 corporation for very bad reasons. And many of these parents, and I've acted as a guardian ad litem. I have represented parents who have been in these types of situations. They're in desperate situations. And there are many people, many children, I think, that could be put in harm's way the way this bill is drafted now. So that is one of the reasons we're opposing this, and we'll ask that you do not report it today.
Well, thank you very much. I would, if it is the pleasure of the committee, and first of all, I want to point out that Senator Stanley really did an outstanding job of presenting the bill and was a zealous advocate for it. He almost wore us out, but not completely. If you want to, I would expect you to take the Fifth Amendment. My suggestion with great reluctance and respect for the patron is I'd love to see more. It sounds like it's something that we ought to look at, and I hadn't heard of this before this year, but the Department of Social Services is looking at it. It would be my hope that if it is the pleasure of the committee not to report this, that it would go to the Department of Social Services for continued study, and then we'd be back here next year, that we would continue it and take this up next year, hopefully with some recommendations. But it is up to the committee.
Mr. Chairman.
Senator McDougall.
Mr. Chairman, my seatmate was very zealous in his presentation or advocacy, but I do think that there is still the concern about the protections, the way the wording is written. So I would move that the bill be carried over to the 2019 session, and maybe the chairman could send a letter to the Department of Social Services to ask for their input on oversight of the organizations while it's within the committee between now and 2019.
All right, is there a second? All right, that motion's been made and seconded. Carry the bill over. Any further discussion? Clerk will open the roll.
Thank you for your time.
Thank you, and we'll look forward to seeing you and Senator Stanley back with the Department of Social Services next year. And for the House patrons who are here, we've got quite a lineup and quite an impressive group of patrons here. And you may want to just make sure that your staff can find you. I don't want to tie everybody up for the entire afternoon. I'll give you the lineup of patrons in order of their sign up, and we will gladly call you and get you down here. The lineup is delegates Rush, Freitas, Ward, Tyler, Wilt, and Peace. That's the at least the first 2, 4, 5 people signed up. So for those of you who would like a phone call, we will gladly. You're probably signed up. Don't worry. If you've got a bill, we'll call you. Okay? Delegate Rush.
Thank you,
There he is.
Mr. Chairman, members of the committee. This bill is not quite as weighty as the last. It is
What's your bill number, Delegate
House
Rush?
Bill 362.
All right.
It deletes two words from the code, full and time, and it allows the Department of Lottery to hire part-time investigators as well as full-time investigators.
And so what's the need?
They would like to hire a part-time investigator for some of their lottery activities.
Right. Like stores or people with
Yes,
fraudulent
yes,
tickets?
Mr. Chairman. Yes, Mr. Chairman.
All right. Anybody have any questions of the patron? Anybody from the audience wish to speak in favor of or in opposition to the bill? It's been moved and seconded that the bill be reported and re-referred to the Committee on Finance.
Oh, never mind.
All right. Clerk will open the roll.
Just kidding.
Very good. All right, the bill is reported. Is that it?
No, one more, Mr.
All
Chairman.
right, what's your next bill?
It's House Bill 364, and this bill was brought to me by a local police chief in Pulaski County. This would allow for temporary detention orders to be delivered by the deputies or local correction officers for inmates. It's a kind of efficiency bill.
All right. Anybody have any questions of the patron? Anybody in the audience wish to speak in favor of or in opposition to the bill? Look to me as if staff and council had no concerns about this bill. All right, it's been moved and seconded the bill be reported. Clerk will open the roll. All right, congratulations.
Thank you, Mr. Chairman, members of the
Yes,
committee.
sir. Next, we've got Delegate Freitas. Welcome back.
Thank you, Mr. Chairman. And I've got two as well. Do you want me to start off with?
Which one do you want to start?
HB 900 forfeiture
900?
property. So, Mr. Chairman, I understand, I believe so what HB 900 does is a civil asset forfeiture reform requiring a criminal conviction or plea agreement before property can be forfeited. It is, I would say, different enough from Senator Peake's bill that I wouldn't want to conform it. I understand the fiscal impact statement that I received on it essentially said that because of the exceptions that I have in the bill with respect to forfeited assets, and if you look at the current state within Virginia on how assets usually do become forfeited, the fiscal impact would most likely be minimal, but I understand if that still requires a refer to finance. And I'm happy to answer any questions.
All right, anybody have any questions of the patron? Anybody in the audience wish to speak in favor of or in opposition to the bill? Step right up. Those in favor first.
Mr. Chairman, members of the committee, Claire Guthrie Gustiniaga on behalf of the ACLU of Virginia. We strongly favor House Bill 900, as we did Senator Peake's bill as well. We think it's extraordinarily important that we move toward fairness in this area and demand that there be a criminal conviction before somebody's property can be taken and forfeited. According to the State Crime Commission report in 2015, 65% of law enforcement agencies reported not requiring a criminal charge against someone before referring a civil forfeiture case to the Commonwealth's attorney, and 60% of the Commonwealth's attorneys didn't require a criminal charge against someone before an information was filed for a related civil forfeiture case. So it is the case that in a majority of cases, these matters are moving forward without a criminal conviction. Look, the ACLU totally supports taking action to deprive criminals of the fruits of their criminal activity. But we think it is time for Virginia to stand with at least 13 other states and take the position that we shouldn't take people's property when they have not been convicted of a crime. Thank you very much.
Thank you.
Mr. Chairman, members of the committee, my name is Steve Rossi. I represent the Family Foundation of Virginia. We echo Claire's remarks, and I guess it's appropriate on Ash Wednesday, a miracle has happened with the Family Foundation and ACLU on the same side of an issue. Thank you, Mr. Chairman.
Thank you. All right. And anybody in opposition? Yes, sir.
Good afternoon, Mr. Chairman. David
Are you here
Ledbetter.
in favor?
No, sir.
Ah,
Mr. Chairman, David Ledbetter, Commonwealth Attorney of the City of Waynesboro. I'm here on
I
behalf of
thought
the Virginia
miracles were
Association.
continuing.
Virginia Association of Commonwealth Attorneys, and we stand opposed to the bill. First of all, a few things. In 2015, the Crime Commission studied this issue in Virginia. They found there was not a problem with state asset forfeiture in Virginia. They did not recommend any changes. Remember, the standard has always been to not deprive somebody of property without due process of law. The Virginia system as it is now has that due process. It's just like a civil lawsuit. They're entitled to notice, opportunity to be heard, discovery, even right to a trial by jury before their property is seized. Would also note that the bill as it stands does have a fiscal impact. This bill, as HB 900, has automatic stay provision. That means the law enforcement agency that sees property must maintain that property and preserve that property during the time of that automatic stay. And remember, the asset forfeiture goes beyond cash. It goes to automobiles, lab equipment, and also real property that's used in substantial connection with the distribution of narcotics. There will be a fiscal impact on that. A couple other points as to see if there is a problem. Senator Peake introduced Senate Bill 813, which is a study bill where the report from the agencies would have to report back on the criminal convictions tied with asset forfeiture. We would submit that. We should study and see what that does. In addition, remember last year we raised the standard of proof to clear and convincing evidence beyond the preponderance of evidence. And then the final thing is under the scheme set up under HB 900, there's a regular perverse incentive system because if property can be seized, if there's a plea agreement, somebody, a wealthy defendant that we've seized his assets, there's a perverse incentive to give him the plea agreement to have the benefit of being able to seize the property. So we would stand opposed to the bill.
All right, thank you very much. Next.
Mr. Chairman, Keenan Hook with the State Police. We share the Commonwealth's concerns. We believe that clear and convincing is an appropriate standard for dealing with these forfeiture cases, and to raise the bar further not only will make it more difficult for us to interrupt the financial incentive to commit crime, it will also delay the finality of judgment and make it more logistically difficult for law enforcement to do what we need to do.
All right, thank you. Yes, sir.
Mr. Chairman and members of the committee, I'm John Jones, representing the sheriff. We are opposed to this bill. This issue came up 2 years ago. Longer than that, it was referred to the Crime Commission. There were some efforts made to correct the deficiencies in Virginia. We had a few roadside waivers. We did away with that. A lot of the hype about this issue was in other states and the federal system. In fact, now the federal system is tracking what we're doing in Virginia to some extent. So it has a financial impact on sheriffs. When we're opposed to the bill, we hope you don't pass it. Thank you.
All right, thank you. All right, anybody have any other questions? The bill is before us and it has been requested to go to finance.
I'll make the motion. Second.
All right, it's been moved and seconded to report and re-refer to finance? Yes. Okay. Clerk will open the roll.
Ayes 12, noes 2.
We'll see you in finance.
Thank you, Mr. Chairman.
All right, next.
Next bill is HB 902, and it has to do with making some modifications to the sex offender registry. We had an issue where certain crimes that would get you on the sex offender registry, had you committed them in Virginia, it would require up to 25 years to be able to apply to get off of the registry. But we forgot to carry over the other language that says if you've been convicted in another state, it still requires 25 years. So currently under the law, if you've committed the crime in Virginia, it can take 25 years to get off. But if you committed the crime in Maryland, you could start to appeal to get off at 15.
Right.
So we're simply just making sure that that
And
carries
it's
over.
got a foreign country report, provision as well.
That's correct.
All right. All right, anybody have any questions of the patron? Anybody from the audience wish to speak in favor of? In opposition? All right. It's been moved and seconded the bill be reported. Clerk will open the roll.
Ayes 14, no 0.
All right.
Thank you, Mr.
Great.
Chairman, members
Yes,
of the committee.
sir. Delia Ward.
Good afternoon, Mr. Chairman, members of the committee.
You look marvelous.
Thank you, thank you. House Bill 1343. It amends the Code of Virginia relating to notaries and their fee agreements. Currently, the code states that it's unlawful for an employer to require a notary in his employment to surrender to the employer a fee if charged. What this means is, and I really bring this on behalf of a business in Hampton, it's a packing mill and it does quite a few services. It will make copies for you, it will fax, it will notarize documents before mailing them. And that employer can charge for the copying, can charge for faxing, all those things. But in his employment, he may have made sure that one employee becomes a notary. He might have helped with the fees or licensing, whatever. But that person, even if that person is on the clock, if there is a charge for notary services, that fee has to go to the notary, even if that person is on the clock working for this employer. So what this bill does, if it passes, the employer may require the notary in his employment to surrender the fee.
And let me ask you just a couple of quick questions.
Mhm.
One, I mean, this is a 180 change in the law. I mean, the law right now says it shall not be lawful. And I read that in conjunction with the first paragraph of this statute that says that an employer, as a condition of employment, can require their employee who's a notary to perform the notary services without charging a fee. And so as I read this, I thought that it meant that, that they went hand in hand, that the employee, in the course of the employment, wasn't going to be charging a fee.
Mhm. That might be the case, perhaps, in law firms, practices where something is notarized and the client is not charged a fee. But for other businesses, there is a fee to have a document notarized. There is a fee for having something faxed, those types of things. And in that case, right now, it's unlawful for that employer to take that notary fee.
So you have employers employees refuse to turn over the fee?
That's basically it. And they're on the clock. And we're not trying to take away money from all the notaries, but you got to do it outside, not while you're on the clock.
All right, so they did it after 5 o'clock, it's theirs.
Do it in the parking lot, whatever. But if you're doing it right here while you're on the clock and your boss, and it's a part of that business to
All right.
fax, to copy, to notarize.
Anybody have any questions to the patron? Anybody from?
Mr. Chairman?
Yes, Senator Howe.
Not to, this is a fine bill, but one of the things I have never understood is why do we have notaries at all these days? They're nothing but an inconvenience to almost everybody, and they serve almost no purpose, but that's just my aside.
Well, until we eliminate them, I guess we got to go by the code.
All right, anybody else have any questions? Kristen?
Mr. Chairman, if the intent of the patron is for the fee to only be charged while the notary is on the clock, then I think at the end of line 16, we need to add language saying for acts performed in the course of his employment. So if he's performing notarial acts after 5 o'clock, then the employer could not charge for those.
Correct.
So Senator McDougall suggests the reverse, saying unless performed in the ordinary course of the business of the employer.
So, Mr. Chairman, the amendment would be to put back in the language that is stricken in B and add that language.
Yeah.
Okay.
All right, that language has been moved and seconded. Do you have any objection to that?
Could I hear it again?
It basically provides that it limits it to notatorial acts performed during the course of the employment.
Yes,
Okay.
that's fine.
All right, that motion to amend has been made and seconded. All in favor signify by saying aye.
Aye.
All opposed, that amendment's made. Do you have a question, Richard? All right. Okay, the bill is before us. Anybody from the audience wish to speak to it? Is there a motion on the bill? All right, motion has been made and seconded to report the bill as amended. Clerk will open the roll.
Ayes 13, noes 2.
See, he just wants to argue against it on the floor and doesn't want to do it in here.
Valentine's Day. Where is the love? Thank you, Mr. Chair.
All right,
members
thank
of the
you very
committee.
much. Delegate Tyler. Welcome.
Thank you. Mr. Chairman, I have House Bill 1435.
All right.
Basically, House Bill 1435 was introduced at the request of an attorney by the name of William Newsom, who is here today. Basically, Mr. Newsom brought forth this bill to me because he has been trying to address an ongoing problem of trying to get the necessary information from the clerk's office in a timely manner, especially regarding his garnishment cases. He's very concerned because he continued to pay for services and no services are being rendered sometimes until 3 months later. Currently, there is no statute or court rules that set a time frame for the clerk's office to file, process, and issue civil cases. Basically, the court clerk handbook only says that the civil case must be handled timely. Therefore, House Bill 1435 just gives a time frame. Within 14 days of receipt of a pleading, initiating any civil action in the general court, including an action for garnishment, the clerk of such general district court shall file, process, and issue the service of processing such pleading. And this bill passed the House of 80-19, and Mr. William Newsom is here today.
All right. Well, thank you very much. We'll gladly hear from Mr. Newsom and anybody else who wishes to speak for this bill.
Mr. Chairman, fellow senators, I'm having a major issue with several courts. The problem is we're filing civil documents, warrants in debt, or garnishments. They got all backed up when we started complaining. They told us they couldn't do any better. When I got to investigating, I found out there was no Supreme Court rule or a statute that sets any sort of time requirement on how long the clerk has from the time you pay a court cost to when they actually process the pleading. I have one example. In one court, we filed approximately 200 garnishments. They took our money. It was over $2,000 in costs. They sat on the garnishments for 4 months. By the time they issued them, it was 30 days from the return date. We've also had issues with warrants in debt. I have one court that requires us to send it to them 8 weeks prior to the court date. My clients are finding it unacceptable. As just a common sense issue, I don't feel like the client is getting what they're paying for. They're paying a court cost. The clerks are taking it, cashing the check, keeping the money, but they're not doing the work until 3 or 4 months later.
Thank you, Mr. Newsom. Appreciate that. Anybody else wish to speak in favor of the bill? Yes, sir.
Mr. Chairman, members of the committee, Reese Wilkes on behalf of the Virginia Creditors Bar Association. We support this bill, and we're also going to support what Mr. Newsom said. This has been a systemic issue for a number of years. Not only is it a concern that funds are being cashed and work is not being done for numerous period of time, but it's also trying to resolve the issue. Unfortunately, leaves the creditors in somewhat in an awkward position because they have nothing to rely on. And unfortunately, the only thing they could potentially rely on is ultimately a writ of mandamus, and which nobody ever wants to do. So by virtue of that, this provides a little bit more cover that gives the clerks the requirement they must do this in a specific period of time. We would ask the committee to pass the bill.
Senator Stewart.
Yes, sir.
Yes, I'm curious as to which courts you're having this difficulty in.
We have had courts down in, some of our members down in the Tidewater region. that have been going on and off for a number of years. Normally what happens is that we will have some discussions either with the Office of the Executive Secretary or with the court itself asking that the matters be resolved. We've also known that courts have actually rolled up their arms, judges have actually come in to try to clean up some of the backlog. And normally what happens is that they don't have the staff capable of handling the volumes that are coming in. Either people are leaving or they don't have the budget to actually hire clerks, whereas that clearly is an issue. Unfortunately, it does become somewhat of an issue if it so happens from a due process perspective. So and also to mirror what Mr. Newsom said, we have had on and off, we have had issues with other courts as they come up with these concerns.
And so what timelines are you seeing?
To mirror what he has said, we have seen them as far out as probably 4 or 5 months of a delay where some of the clerks will contact up the individual creditors and say, can you please give us an additional return date? Because we've got to push this out. We haven't been able to process your paperwork. And 90% of the time, we don't have much of a choice, so we have to push it out.
All right. Any other questions?
Thank you.
Senator McDougall.
Mr. Chairman, before he walks away, I think there's some of us that practice regularly, even if it's not in the creditors arena, and I've not heard individuals from the creditors bar bring this to our attention. So can you give us some sense of how many jurisdictions this is occurring in?
So it consists, and I guess to kind of answer some of Senator Stewart's concerns as well, is that I think we have had some of the consistent problems with the same courts over and over and over again. So if you're looking for a percentage, it's probably somewhere between 10 to 15% of the courts where we've had these concerns on a regular basis. And again, what we'll do is we will contact up the court, or we will the member will contact up the Supreme Court and try to act as a middleman to solve the issue. It'll get resolved for 6 months, a year, something like that. And then the same thing will happen again. So, Senator, I'm not sure if you're looking for a percentage or if you're looking for actual names of courts.
Well, maybe offline, I want the names of
Yes,
courts.
sir. Happy to do
We
that.
want that. But I want to know how many district courts. Is it 4? Is it 24? Is it 54? How many district courts?
So we've got, in the Commonwealth, I think we've got somewhere in the neighborhood of close to we have 31 districts, so it's about 121 courts on and off. And so it's probably going to be somewhere at any given time, somewhere in the neighborhood of about 10 to 15 courts where this is ongoing. And to actually expound on that, some of these are very, very large courts. So these are urban courts where we've had very major issues where they're bulk filing. They've got very high volumes. And for whatever interesting reason, they just cannot handle the volume at the time.
All right. Thank you very much. Anybody wish to speak in opposition to the bill? Let's hear from the Supreme Court. You don't, and I know that you don't condone the delays, and I think that any of us who practice and have dealings with general district courts who've experienced delays, I mean, have been frustrated by it, and I know that that it is an issue. I'd be interested in court's take.
Well, my name is Brandy Singleton. I'm with the Office of the Executive Secretary. The Judicial Conference for District Courts does oppose this bill. To provide you with some backdrop for the stories that you're hearing, Senator McDougall, we have 22 courts in the Commonwealth that are below 80% of their full staffing model. So if we only have 10 to 15 courts that are having systemic issues, we're doing pretty good. Statewide, the district court system is 261 funded FTEs short of their full staffing model. So I do not deny that the problems described here today are a problem, and it is going to get worse. You have people with 35, 40 years experience who are retiring. The demands of the position, coupled with the salaries that they are paid, makes it very hard to replace those individuals, and it makes it very hard to retain younger individuals in these positions. That's on top of even if all the positions were fully funded. So I'm just here to give you that background because I fear of the next decade we have a real problem coming.
Mr. Chair.
Senator Deeds, that's fine.
I think Delegate Tyler's bill's identified a very real issue, and my
Absolutely.
question is, if 14 days is too much, what's the
Right.
Executive Secretary's office willing to live with? Because I think this is a good idea.
I'm not here to say that 14 days is too much, and in fact, I will tell you, what I'm here to say is that this bill does not solve the problem that it identifies. If you have a court that is taking 14 days to turn around service of process on civil pleadings, there's a real problem there. On the other hand, I don't want to send the message to courts that are properly staffed and well-managed that you can sit on civil filings for 14 days before you turn them around for service.
Mr. Chair.
Senator Peterson.
Okay, I know a little bit about this. And for example, as a practitioner, I may be understaffed in my office, but I got to answer a complaint within 21 days, okay?
Sure.
I've been in this business long enough. I've never met a government agency that felt they had enough money, okay? And so the bottom line is we all have to be accountable to time standards. If you don't think 14 days is right, we can make it 20. We can make it 30.
What I'm
But
saying
the
is-
bottom line is, as a practitioner, you need to have certainty when you file that case that a summons is going to be issued.
I understand. I will say the difference in what you have described is that as a practitioner, if you know you don't have the capacity for the work, you can turn it away. The courts do not have that option. So, I mean, I think what a lot of courts are doing to try to manage this is they have to push the dates further out, and particularly for civil filings, because criminal comes first. And once you get into the civil realm, then unlawful detainers come first, because you have to schedule those hearings within 30 days of receiving the pleadings. So if you make everything first.
So you're saying that.
How do you order that?
So you're saying what you would do to meet this 14-day deadline would be to divert staff from the courtroom into the back office, the clerk's office, push cases farther out, and get cases stamped and filed. But if you get them stamped and filed, you may not get a hearing for a month or 2 months or 3 months longer, given the current staffing levels.
That is a potential consequence.
All right. Is the court actively looking at this issue?
We currently have 2 budget amendments pending that Senator Vogel is carrying for us. We realize that we're not going to get funding for 261 district court positions. We have asked for 10 positions each, 20 total, 10 for the J&DR court system and 10 for the general district court system.
Well, but beyond asking for the additional clerks, I mean, is the Office of the Executive Secretary currently looking at alternative means of addressing this backlog and preventing this kind of delay?
So what we do in these situations are identified to us, as Mr. Wilkes indicated. When we get notice of that, we do have technical staff that works with individual courts on their processes.
Well, my question, though, is more pointed. I mean, now you're on notice that statewide this appears to be not just an issue in an isolated place or two. Is the court, and I don't know what the pleasure of the committee would be, but if the pleasure of the committee is to wait and come back next year, are you all in a position to look at and take affirmative steps to try to implement contingency plans to get these courts caught up? Or should we, let a bill out?
We continue to work with individual courts in our long-term planning processes. Yes, these are issues that we discuss, and I'm simply not sure if that answers your question.
Mr. Chairman.
Will you do something?
I'm not sure what the solution is if there aren't enough bodies to process the number of cases.
Senator
Mr. Chairman.
McDougall.
How many jurisdictions do you have personnel that exceed 90% of the staffing model?
Because my list is set up in the opposite direction, I would have to count individually, but I'm also happy to leave this report with
Are
you.
you saying there's more, Mr. Chairman? Are there more than 1 or 2 jurisdictions?
When I glanced through the list earlier, I noticed at least 2 that were at 100%.
Mr. Chairman?
Senator McDougall.
Has the Executive Secretary made any effort to transfer personnel from jurisdictions that are fully staffed to those jurisdictions where there are problems?
So, for example, your fully staffed jurisdictions, Fairfax is one that is fully staffed. your ones that have, the geographical dispersion tends to be such that that would not be practical. On a case-by-case basis, we do work with courts to get assistance for backlogs from neighboring jurisdictions.
All right.
Mr. Chairman,
Sarah Howell.
I'm just curious, are jurisdictions like Fairfax putting local money in?
I'm sure they are.
Yes. So, Mr. Chairman, I would suggest transferring them from where they're being locally funded to somewhere else would not be real popular.
Mr. Chairman.
Senator McDougal.
District courts are not locally funded in the clerk's office. Circuit courts could be, but district courts are not.
I think Fairfax has an add-on. You may be wrong about that. I don't know.
All right. I think we've all got the issue. Is there,
Mr. Chair.
You want to, Senator Deeds?
I move to report the bill.
Okay. Yeah. Is there a second? All right, Senator Stewart.
Mr. Chairman, I'd like to make a substitute motion that we carry the bill over for the year. This is a difficult issue, and I know that some folks are frustrated, but we also have to remember that some of this gets tied up within the Fair Labor Standards Act, and it gets kind of complicated. And I don't know how this committee can sit here and set an arbitrary time limit on these. And I think we need to have the court's input on it. So if we carry it over for the year, that would allow us to hopefully work through that.
Mr. Chairman.
Is there, hang on, is there a second to that? All right, there's a second to the substitute motion. Senator McDougal.
Mr. Chairman, I have very, very mixed feelings about this because I want to move it forward, but again, I don't know that even if we move the bill forward, that it's really going to solve the problem. But as we're going through the budget process, it seems pretty stark to me after listening to this conversation that we should be approving no new judges, that we should be putting that money into the clerk's office for additional positions based on what I'm hearing out there. So whether Senator Stewart agrees with that, but I would say it does give pause for conversation if the actual litigants filing paperwork are not getting that paperwork responded to, that is the higher priority need than new positions above what's been funded over the previous year.
It's a very timely observation, given what we
Mr.
have to
Chair.
do over the next week.
Mr. Chair.
Senator Peterson.
I'll make one last point. So much of this is self-funding because if you file a suit in general court, you pay the filing fee and the service fee. If those fees are too low for the personnel that are necessitated, then adjust the fees. I'd rather pay a couple bucks more on the front end and know that a summons is going to get issued than have to wait around for 60 days.
Yeah, we're not coming back. We've got a substitute motion to pass the bill or carry the bill over. And if it's carried over, I really would like for the court to look at this, make recommendations, because I totally agree. I mean, it's wholly unacceptable to have that kind of delay, and we can't allow that to continue. So the motion is to carry it over. Clerk will open the roll.
Ayes 10, noes 5.
All right, and I will write a letter to the Office of the Executive Secretary and ask the Committee on District Courts to work on this, and we expect to see you back next year.
Okay, thank you, sir.
All right, thank you. All right, Delegate Wilk. House Bill 1142.
Thank you, Mr. Chairman and committee members. House Bill 1142 provides that circuit court or a circuit court clerk may allow a fiduciary to qualify by giving bond without surety when the asset or amount coming into the possession of such fiduciary has no monetary value. What's happened, Mr. Chairman, is that some clerks' staff interpret the current code because there is language there that the $25,000, you can't exceed $25,000, and so even when there's zero assets, they say that there has to be an asset for you to qualify, and so they tell the person trying to qualify, just say there's $1. And so this makes it clear that zero, if there's zero amount assets, that the person can qualify.
What court is doing that?
Mr. Chairman, the issue was brought to me by a lawyer.
Someone close to home?
Someone close to home, Mr. Chairman.
Mr. Chairman?
Sarah McDougal.
Maybe my math is just not on today, but it would seem to me that if the, two questions. One, if there's no value, why are you qualifying? But second, if the statute reads does not exceed 25,000, so zero is less than 25,000. So why wouldn't that qualify under the current statute?
Mr. Chairman, I would agree, but there have been situations.
Why don't we ask Mr. Dix to explain why the clerks appear to be taking this seemingly unusual position?
Well, Mr. Chairman, this seems to be the day for wills and trust states like on the floor of the Senate.
I
don't know whether.
You're here for the clerks, not the Virginia Bar Association, right?
I am here for the clerks. So the situation is that oftentimes there is no cash value, and if there's no cash, then the question with the current language is that if it doesn't exceed $25,000, but the widow, let's say, has stock and it's jointly held and it goes into her name, then the question is, she still, in order to transfer that stock, needs something from the court, and the clerk, in some cases, Mr. Chairman, does not feel authorized to give the widow something that she can give the bank who requires something, or the bank that's going to transfer the stock. So that's where the problem comes in. And one of our clerks had that experience personally with when his parents died, and the clerk in Fairfax could not get the bank to be willing to transfer something from the father's death to the mother that was jointly held because they were looking for something from the clerk's office, and the clerk's office didn't feel in a different jurisdiction that they could provide that. So
Mr. Chairman?
That's what the situation is.
Sarah McDougal.
Doesn't the court have the ability to go in and override that determination and qualify the individual?
Mr. Chairman, I would say that the court does. I think the challenge is when somebody comes into the clerk's office, the probate division, and wants to do something, the clerk, a number of clerks don't have a problem with this. A number of clerks do have a problem with this. The purpose of this is simply say, if there's not cash, but there's some other asset that's worth less than $25,000, that the clerk can qualify that person as fiduciary, and then they'll have a document they can take to a bank or other institution and be able to transfer the asset.
And the answer to that coming from the commission does not exceed 25,000. Zero does not exceed 25,000.
It probably should say, Mr. Chairman, if I could, on line 17, instead of monetary value, or should say and, perhaps, does not exceed.
Mr. Chairman.
Oh, so instead of saying, all right, go ahead, Senator Stewart.
Chair, I'm not the brightest, and I admit that, but I don't understand. It's perfectly clear to me that zero does not exceed 25,000. Zero does not exceed 25,000.
Mr. Chairman,
And I was an English major, not a math major. But I don't understand why we need to change this. That's just.
So, Mr. Chairman, I think maybe I didn't describe the problem well, and this is not my field of expertise at all. So I'm taking what somebody else has given me as the correct information. I understand that if it says does not exceed $25,000, that talks about assets that basically could be liquefied into cash. In the circumstance that was described to me, there was a husband who passed away, and the wife inherited the stock, but the stock was worth less than $25,000. But the clerk close to home didn't feel, because it wasn't cash, that they could qualify the widow so that she could go to the bank and have the bank transfer the stock into her name.
Is this just one clerk or multiple clerks?
There's one clerk in particular, but there are other clerks who also feel the same way when we polled our 120 clerks. The vast majority of clerks feel like the law is clear. There's a contingent of 25 or so clerks that don't feel like the law is clear.
Mr. Chairman.
Senator Stewart, Senator
So
Gates.
how would this bill get you a different result under that scenario?
Mr. Chairman, I'd say to Senator Stewart, the clerks that are concerned about the existing law would say that if it has no monetary value and it's less than $25,000, then it's really the change is on line 15 with the asset or the amount. Because if the asset, the stock itself, that's the asset in this particular case.
So
that gave rise to this bill.
Are you okay with just that language, the asset or the amount?
But if it has no monetary value, it doesn't exceed 25,000.
So
that's what's hanging me up here.
So, Mr. Chairman, I think the key change is on line 15, asset or amount. And as long as it's clear, the thought of the trust attorney who wrote this was that on lines 16 and 17, cash dealt with and referred back to amount on line 15. And what he was trying to say is that the monetary value related to the asset. So if it's clear to this committee that what we're talking about is an asset or amount, and then we don't need has no monetary value so it would say asset or amount that doesn't exceed $25,000, I think that solves the problem.
Yeah. All right, so you think that would clear it up for 25 clerks if we said something to the effect that has a monetary value that does not exceed $25,000 or something like that? Kristen?
Yes, I think that would be great.
So we're not stating the obvious twice?
Can the Clerks Association send a memo, Chip?
They need a real trust.
All right, did you have language that you wanted to suggest?
Mr. Chairman, I would suggest that on line 16, you strike no and insert a monetary value that does not exceed $25,000.
All right. You want to make that motion? All right, it's been moved and seconded, that amendment. All in favor signify by saying aye. All opposed? All right, I think we understand the bill. Anybody from the audience wish to speak in favor of or in opposition of the bill? Anybody have a motion on the bill as amended? It's been moved and seconded. The bill be reported as amended. Clerk will open the roll. All right. Thank you very much.
Thank you, Mr. Chairman, committee members.
All right, next we've got Delegate Peace.
Afternoon, Mr. Chairman, members of the committee. We've got House Bill 856.
All right.
Mr. Chairman, members of the committee, House Bill 856 is really a bill that clears up some inconsistency statewide among courts regarding the application of some legislation that was passed last year. And it would clarify that a plaintiff is permitted to request immediate possession as part of an unlawful detainer filing, but that would not be able to occur prior to the expiration of a tenant's 10-day appeal period. Mr. Chairman, members of the committee, I believe it's supported by a number of entities. I won't list all of them, but I believe there's Peace in the Valley. The Poverty Law Center has been consulted. There was an amendment that they requested that was added to the House bill on the House side.
So y'all didn't like what we did last year?
No, we liked what you did, Mr. Chairman, but I believe that it hasn't been applied consistently, so we want to add that clarity.
Okay. All right.
Hold on. Mr. Chair.
Senator Peterson.
So if somebody abandons the property and I come in and I file for an unlawful detainer and I go to court, they don't show, I still can't actually go in and take possession for another 10 days, even if it's abandoned. I got rats running around there.
Mr. Chairman, I would just say, Senator, when the court grants the order of immediate possession, the housing provider must obtain the writ of possession from the clerk and the sheriff schedule the eviction. You know,
but you're saying I got rats running around there, and for 10 days I can't do anything.
Mr. Chairman, Senator, I would just say maybe you should take better care of your property. And then,
Or maybe if it's been abandoned, you don't need a writ of unlawful
Yeah.
detainer.
I think you do.
Mr. Dix.
Chip Dix on behalf of the Virginia Apartment Management Association and Senator Peterson, if the property's been abandoned, you don't have to file for an unlawful detainer. But otherwise, if the property's occupied and is unlawfully detained from the landlord, then you do file an unlawful detainer. All this bill does is to say that since the tenant has a 10-day appeal period, that the clerk can process the writ of possession during that time frame and post it on the door, but they cannot, under any circumstance, execute the writ of possession and evict the tenant prior to the expiration of the tenant's 10-day appeal period. That's all it says.
Mr. Chair. Mr. Chair. And I understand that. I'm just looking at the stricken language. Previously, you had the 10-day appeal period. I mean, if you're awarded possession, unless there was, quote, a default, or if a trustee's deed following foreclosure, or for non-payment of rent. So basically what we're saying is, even if it's a default, for example, the other side doesn't show.
Right.
You got to wait 10 days.
Mr. Chairman, I'd say to Senator Peterson that in order under the existing law and what was passed last year and what this clarifies, you still, the tenant defendant still has a 10-day appeal period. So the rule has been that you cannot have the sheriff physically evict somebody within the tenant's 10-day appeal period until that expires. All this is doing is clarifying that practice.
Any other questions? Anybody in the audience wish to speak in favor of or in opposition to the bill? Bill is before us. It's been moved and seconded the bill be reported. I don't think we can open the roll, right? All in favor signify by saying aye. All opposed? All right, unanimously reports. Thank you.
Mr. Chairman.
We're having a technological challenge. Delegate Landis, I think you're up next.
Mr. Chairman, I have House Bill 1599. Mr. Chairman, let me explain the bill, and then, as with all good measures, there are folks who want to join in this opportunity. So let me explain the legislation. Mr. Chairman and members of the committee, this bill, House Bill 1599, simply would clarify that the Office of the State Inspector General would have statutory authority regarding their law enforcement functions for their Inspector General's investigators. This legislation came as a clarification that was suggested by the Office of the Attorney General. And, Mr. Chairman, when this came out of the House, we did not have and did not catch the fact that it may have an impact on the Line of Duty Act. And so at some point, if you act on this positively, it may need to go to Finance. But I would also say there are agencies that have come to me since then that would like to be included, and there is a amendment if you wish to consider it, and I would leave that up to the committee and your discretion. I do think if we add the individuals that want to be added, that it would have an even more significant potentially fiscal impact on the Line of Duty Act. And my original intent was to do this for the Office of the Inspector General. It was requested by them. And, but I would leave it up to you all whether the other two agencies should be included. The proposed amendment, and again, I have no position on this, I'd leave it up to your discretion. The Department of Corrections would like to add their internal investigators, and then the Department of Juvenile Justice would like to do so as well. Mr. Chairman, I think they're here if you want to hear from them, but that's simply put what the bill does. And to be quite frank, I think we just missed the potential fiscal impact on the House side.
All right, so do you warmly embrace the efforts to include others within the breast of this bill?
Well, Mr. Chairman, and I see Senator Norman's not here, and Mr. Chairman, you're on the Finance Committee, as a number of others, Senator Howe and others, Senator Saslaw. I think if we kept it in a more narrow scope, it has a much better chance from the standpoint of knowing the Senate Finance Committee, and since that's what the original intent was. But I also want these folks to have a chance to say why it's important that they be considered from a public policy standpoint. I don't want to diminish the importance of those investigators and what they do.
Now, I appreciate that, and I understand. We'll gladly hear from those who support the bill, including those who support rolling their agencies into it. This is not the AG's office.
Hi, Marie
This is not the AG.
Vargo, Department of Corrections. The reason we wish to be added to this is that we have officers in both our agencies that are considered currently law enforcement officers for the purposes of their duties pursuant to the code sections that they work through. These officers have been treated as law enforcement officers and meet the same standard as all law enforcement officers that are certified by DCJS, but they were not listed as law enforcement officers defined in 9.1-101. And the Office of the Attorney General recently determined that DJJ and DOC officers did not meet the statutory definition of law enforcement officers by those code sections to be certified by DCJS, and this amendment seeks to add them to the current definition. If they're not defined as law enforcement officers, DCJS will be forced to purge all existing officers from the certified law enforcement database. This will limit their investigative authorities, such as swearing out arrest and search warrants, and could impact their ability to also request Department of Forensic Science lab analysis. Each of these challenges would impact the agency's abilities to quickly address immediate threats and investigation and would be particularly challenging given the unique nature of these investigations and the geographic diversity with both the location of the facilities across the Commonwealth and the location of the many visitors who travel to them daily from all over the Commonwealth. This would also result in recruitment and retention challenges as officers who continue to be certified as SIU officers with both DOC and DJJ will be at risk of losing their certification. This result in officers choosing to leave to maintain their certification and will impact the agency's ability to recruit strong candidates for these positions. We believe that this is a technical fix, as these officers should have been included in 9.1-101 all along.
So, why didn't you all put a bill in?
It came to us rather late, the opinion, and we just
Delegate Landis's good idea.
We wanted to forward this. We were given the authority to do so at such time, and then Senator Landis was kind enough to consider us.
Okay.
I'm sorry.
Thank you.
Mr. Chairman, Mr. Chairman, I'm missing a link here.
Okay.
Are you implying that by passing Delegate Landis's bill, all of these horrible things are going to befall the Department of Corrections?
No, by leaving them out.
By leaving us out, our law enforcement officers who currently are certified will lose their certification and their ability to obtain arrest warrants, search warrants.
Yeah, I heard
and
that.
sometimes, and that is in the midst of trying to do investigations quickly, we would have to go through local law enforcement or other law enforcement agencies, Commonwealth's attorneys, and we lose valuable time sometimes when we're in the
Mr. Chairman, if we were not to pass Delegate Landis's bill, would these horrible things befall you anyway?
Senator Howell, that is the reason that the Office of Inspector General brought me the legislation, because they got the same Attorney General's opinion. The problem was DOC and DJJ did not maybe have that as early as the Office of Inspector General. So they're all in the same category. I'm not saying that they're not, but the legislation I put in originally was just for Office of the Inspector General. I'm not opposed from the standpoint of what they're trying to accomplish. I'm more concerned about the potential fiscal impact the more we add that impacts on the line of duty. And I think that's the question.
All right. Step right up.
Good afternoon, Mr. Chairman, members of the committee. My name is James Toohey on behalf of the Department of Juvenile Justice. And
Bad
I'll be
things
brief.
are going to happen to you all too.
Yes, Mr. Chairman, it will. And I don't want to be repetitive of what you've heard already, but I would just like to mention that emphasize that the General Assembly through, with regard to DJJ 66-3, paragraph 7, has clearly emphasized its intent that the Department of Juvenile Justice have designated investigators with the authority to conduct internal investigations. And what happened here is that even though the General Assembly included them in 66-3 to do internal investigations of criminal matters within the department, that they are not included in 9.1101. And that's what the issue here now is with DCJS saying, well, they're not individuals that we can certify. As far as the implications that I would just like to mention to the committee, if I may, we have 11 investigators at DJJ. So under the Line of Duty Act, based upon the fiscal impact we looked at for the Office of the Inspector General, we're looking at about $8,000, and that's something that we would be able to absorb currently within our own budget. So even though we'd have to go to finance, it's something that is small enough that we can deal with it. Another thing I would like to mention, Mr. Chairman, is that we're talking about 385 investigations per year that are currently being done that would be significantly slowed down, involving things like PREA, the Prison Rape Elimination Act, and also a lot of staff bringing in contraband into the facility like drugs that cause enormous problems and sometimes need to be dealt with quickly. And our investigators need to be able to get a search warrant as quickly as possible in order to be able to deal with that.
All right. Thank you very much.
Mr. Chairman?
Senator
Thank you, Mr. Chairman.
McDougall.
Y'all have 11 investigators for now less than 300 individuals at DJJ?
Oh, no, I think Senator McDougall, Mr. Chairman, what I had mentioned was that we have 385 investigations per year. The 11 investigators investigate anything involving visitors to the facility, such as parents, volunteers, vendors, as well as staff, and then also any of the activities that go on within the facility.
Mr. Chairman, my statement was that there are less than 300 individuals who are now housed by the Department of Juvenile Justice. So, yes. And you have 11 investigators that deal with the investigations surrounding those less than 300 juveniles and staff.
I would respond to that by saying that they're not responding solely to the investigations involving the number of the residents, but it's also, yes, the staff and parents. Sometimes the issue, Senator McDougall, Mr. Chairman, is parents who come to the facility with contraband and drugs that they then pass off to the residents. So it's a lot more than just the number of residents.
All right. All right. Senator Stewart, I think, has an excellent suggestion.
Delegate Landis, not to put you on the spot, but it is your bill.
Mm-hmm.
Would you like to include these other folks in?
Well,
Or
Mr. Chairman,
go with your bill as is.
Yeah, Mr. Chairman, Senator Stewart, thanks for putting me on the spot. The impact from a VRS standpoint for the Office of Inspector General is estimated to be only $5,646, a round figure. I think the problem is, I don't know, and understand, they say it's 8,000. I don't know how many DOC has. Again, I was just trying to accomplish this for the Office of Inspector General, but you know, I don't want to diminish the fact that we're treating these other investigators separately and differently. You know, I don't know how quickly the Division of Criminal Justice Services is going to act, if they're going to remove people from, you know, their database, as Marie said, but I'm actually asking you all to make the policy decision, since it wasn't within the purpose of the bill.
Senator McDougall.
Mr. Chairman, I'm not necessarily thrilled with any of our decision-making points here, because I'm still having a little challenge understanding why we're in this situation. Maybe I'm having some challenges understanding why we're having all these investigators as well. But I'm going to move that we report and re-refer to this to Senate Finance, and maybe on the public safety side, we need to do a little more investigatory work on why we're here, if it is a correct analysis, and if they're, how we can financially maybe do it for, take care of the problem at a less cost impactful way.
Yeah.
All right,
And Mr.
Senator,
Chairman,
motion's been made and seconded, and I take it, anybody wish to speak in opposition to this? Sorry for short
Mr.
circuiting
Chairman,
that. Senator McDougal.
Even though we're not including the others in at this point, I do think that we'll have a discussion about the impact on all three agencies.
And Mr. Chairman, it may be helpful for Senator McDougal and his staff on a finance. I haven't seen the Office of Attorney General's opinion related to this or communication. That may be prescriptive for and helpful for us as well.
All right. Thank you very much.
Mr. Chairman, sometimes opinions are just that, and they can be wrong.
All right, clerk will open the roll. All right, thank you very much.
Thank you for your time, Mr. Chairman.
Delegate Simon.
Mr. Chairman. Thank you very much. I think there's a committee substitute that needs to be distributed if it hasn't already. May I
All
have
right, Senator Howell moves, Senator Seward seconds the adoption of substitute. All in favor signify by saying aye. Aye. All opposed. Substitutes before us. House Bill 311.
Yes, sir. Mr. Chairman, this bill fixes a problem that was sort of identified during a Fannie Mae v. Parrish case a couple years ago, trying to sort out who decides title issues when there's you've got owners remaining in a property after a foreclosure. We all know they become tenants in sufferance, and the question is, how do you get them out? The way you get them out is you file an unlawful detainer action, just like you would any other tenant in the property. The problem is, if you're going to show up and defend a unlawful detainer, typically what you're trying to do is relitigate the foreclosure. You're saying, well, I shouldn't have been foreclosed on, which is really a title matter. It shouldn't be at the general district court, and that's what the court said in Fannie Mae v. Parrish. Issues of title should be done at the circuit court level. And so the parishes appealed their decision to the circuit court, and the court said they still didn't have jurisdiction at that point because they were on appeal from an unlawful detainer. So at any rate, the way this bill fixes that problem is it establishes a really clean process for how we deal with homeowners who remain in their property after a foreclosure. Not tenants who've been there before, but the homeowners themselves. Says they become tenants at sufferance, creates a notice procedure for them.
Let me ask you, and I know we've looked at, staff has looked at this, I've looked at this. I didn't have any problem with your original, your substitute make any substantive changes, or is it just merely technical?
It's really just technical. It's just a slightly different approach, and it got peace in the valley as far as all the different interest groups were concerned.
All right. Anybody have any questions? Anybody?
Mr. Chair.
Senator Deeds.
Why is this, the person you described, not a trespasser after it's been foreclosed on, sold to somebody else? Why should they be, unless they've challenged the foreclosure, why should they be entitled to be a tenant of any kind? Why shouldn't you just be able to just get them out?
Well, that's not been the case law in Virginia. My understanding is that at the common law, we've always considered those folks that hold over after a foreclosure to be tenants at sufferance rather than trespassers. And so they're entitled to some due process before they're taken out.
Yeah, Mr. Chair, if I might, since we have non-judicial foreclosure, the bottom line is that foreclosure isn't necessarily the last legal word on a subject. People challenge them all the time.
All right. Any other questions of the patron? Anybody wish to speak in favor?
Mr. Chairman, Chip Dix on behalf of the Virginia Realtors, and we asked Delegate Simon to bring this bill and participate in the substitute draft. All the various real property organizations support the bill in its current form, as does the Virginia Bankers and as does the Virginia Poverty Law Center.
All right. Anybody wish to speak in opposition? Bill's before us. Been moved and seconded the bill be reported. Clerk will open the roll. All right. Delegate Yancey. Delegate Yancey.
Thank you, Mr. Chairman. I believe we have one and another was coming your way. I don't know if it's already been referred to or not. But the one that I have is House Bill 1564. This is in regards to the empanelment of commissioners for eminent domain. A local attorney in Newport News brought this to my attention, and the challenge was, Mr. Chairman, that oftentimes in eminent domain cases, judges would have a hard time getting people to be able to attend for some. So what we did, Mr. Chairman, to address the qualified persons in the statute, if you look down on paragraph B and C, we just changed it from the pool of 6 to 8 qualified persons, and then from 9 to 13 in paragraph C. The attorney in Newport News felt that this would allow for a larger pool and therefore more opportunities for people to be able to serve in these matters. And that's all the bill seeks to achieve, Mr. Chairman.
All right. Anybody have any questions of the patron? So this just increases the pool.
Yes, Mr. Chairman, that's it.
All
Okay.
right. Anybody? Sir Peterson?
I'm probably the only person on this panel who's actually tried an eminent domain case with commissioners. Okay, well, I'm not. I'm not the only one. All right, it's unusual.
Well, congratulations. Next.
All right.
Is there a question in there?
Yeah, there is a
Or
question.
just bragging?
No, there's a question. If you make it to 13, the problem is trying to get commissioners. It's different than just issuing a jury summons, trying to get them to court and trying to have enough people to fill what the statutory requirement is. So you're raising it from 9 to 13. That in and of itself could be a reason to continue a trial.
So, Mr. Chairman, Senator Peterson, as
And I
I
know all the
understand,
practitioners understand that, so I'm stating what everyone else knows.
Mr. Chairman, Senator Peterson, as I understand the issue when it was brought to me by the local attorney, he felt that by increasing the pool, it would give an opportunity to be able to select more. As to what the specifics were in some case matters that he had, Mr. Chairman, I can't speak to that. But he felt that increasing the number provided with more opportunities for more people to be able to serve from the judicial panel that would select these members.
All right. Any other questions? Anybody from the audience wish to speak in favor of or in opposition to this bill? All right, the bill's before us. All right, it's been moved and seconded. The bill be reported. Clerk will open the roll. All right, thank you very much.
Thank you, Mr. Chairman. Thank you, members.
Yes, sir. Delegate Collins. $638.
Yes, sir.
All right.
I believe this is to conform with the chairman's similar bill.
Yeah, my recollection is that I had very similar, 638? Yeah. The unmanned aircraft bill, right? And what we did was we took out the trespass provision. Is that right, Kristen? Or Charles?
Yes, that's correct, Mr. Chairman. In your bill, we struck lines 17 through 25.
All right, my inclination would be that we would want to conform this to my version. Would you have any objection to that at this
No,
stage?
I believe that in conversations with the stakeholders, I believe that is a plan of action that we can all get behind at this particular point in time.
All right, so with the understanding that if it's a pleasure of the committee, the motion would be to conform and report. Let's hear from folks in the audience who wish to speak in favor of this bill.
Mr. Chairman, members of the committee, David Skiles with the Vector Corporation representing DJI, which is a drone manufacturer. We testified during the Senate committee hearing on Senator Obenshain's fine piece of legislation, and we obviously support this legislation as well. Thank you very much.
Thank you.
Mr. Chairman, Josh Levy with the Northern Virginia Technology Council also want to express our support for this legislation.
Mr. Chairman, members of the committee, Patrick Cushing with Williams Mullen on behalf of the Unmanned Systems Association of Virginia, and we support the bill and happy to see it keep moving. So thank you.
All right. And in opposition?
Mr. Chairman, Mary DeVoy, I'm not familiar with your bill. What number is it? No one said it here today, since it's conforming.
It was Senate Bill 525.
525. Does it
Yeah.
have a registered sex offender portion to it?
It does.
It does. Okay, then I will continue on. So this bill, your bill as well, balances protections for the operators as well as citizens' privacy. However, for anyone listed on the sex offender registry, there are no such protections. Without including the words coerce, intimidate, or harass, there is no criminal component, which makes this bill overly broad. Including the words knowingly and intentionally in no way lessens the burden. If a registrant is using a drone on their own property and they capture an image of a trespasser, they've committed a crime. If they capture an image of their spouse or their own child, they've committed a crime. If their job includes using a drone perhaps to land survey where workers are present, they've committed a crime. If they are flying their drone over a public street, a park, a forest, where there is no expectation of privacy and they capture any image of anyone, they've committed a crime. This is not equal protection under the law. I envision in the vain attempt to enforce this law, any registrant that owns a drone would be subjected to multiple baseless investigations simply because they are a sex offender. This bill is essentially a ban for all registrants to ever operate a drone, while cleverly avoiding such words as prohibiting. Back in September 2015, the Wisconsin Court of Appeals overturned a law banning registered sex offenders from taking photos that capture the image of a child in public as a First Amendment violation. This bill bans any image of anyone, anywhere. The Virginia Registry must remain an administrative tool and cannot be used as a blanket excuse to eliminate freedoms afforded to everyone else. I'm asking that lines, I had it as 27 through 29 for the House version, whatever they are for yours, to be stricken, please.
And thank you. I
Thank you.
appreciate your faithful advocacy.
Yes, sir.
I mean, these are tough issues, and you've been testifying in front of this committee for years, bringing these issues to our attention. Mr. Benjamin and I have talked about these issues and your advocacy, and I think they're important issues. And we've tried to raise the profile and make sure that we aren't stepping on the rights of people who are required to be registered. And what I would tell members of the committee is that I know that there is perhaps some ongoing discussion about the impact on this interplay with a couple of local government issues, and it would be my commitment to take a look at the issues that you resolve should this bill continue to move forward. I think you raised some interesting, provocative points that I hadn't heard before. So this has a good ways to travel if it's conformed and reported. I would anticipate that it's likely wind up in conference. So I thank you.
Thank you.
All right. Is there a motion on the bill? Conform and report?
Conform and report.
All right. Second? All right. Clerk will open the roll. All right. Thank you very much.
Thank you, sir.
Next, Delegate Lindsay.
Good afternoon, Mr. Chairman, members of the committee. I'm here on HB 1310. Simply put, HB 1310 is intended to amend the present statute 16.1, 69.55 as it relates to the retention of court records and allowing for the electronic formatting of the same. It is discretionary in nature, and it provides that the chief judge of the district court can instruct the clerk of that court to retain certain records electronically, either by microfiche or through other electronic format, and to destroy the originals of those records. It makes certain to stay in keeping with the present statute that says that the microfiche records cannot be in the category of records that are important for public retention, such as those that are the result of certain criminal convictions.
All right. Now, my understanding is that right now the current rule is that courts have to retain these records for 3 years if they're maintained in electronic format, and this bill is going to allow them to be destroyed immediately after the case is ended if the chief judge essentially establishes that policy.
That's correct.
Basically it?
Yes, sir.
I am curious, and I see the members of the Supreme Court staff back there engaged in conversation. I'm interested in whether the Supreme Court has any input or views or thoughts about this. Or you like it?
I know that they've weighed in, and as a matter of fact, they suggested legislation.
Ah.
The judges who took a look at this bill were in favor of it.
Okay. Any member of the committee have any questions? Senator Edwards.
Yeah, Mr. Chairman, well, I understand you're deleting the 3-year rule, which is a good idea, but the records, so basically any time the judge wants to get rid of them, they can, so long as they've been microfilmed, is that right?
Yeah, or retained electronically. The problem right now, even though it's discretionary, the problem right now is that jurisdictions aren't inclined to do both, and so they want that discretion, of not holding the records for 3 years.
Well, right now, the 3-year rule would be gone.
Correct.
But they would have to microfilm them,
Well, I don't think we've been microfilming since the Cold
Well,
War.
what are they?
Yeah, they have to,
Well, it
they
says
have to
microfilm.
digitize them or have electronic
Yeah,
copies.
it says microfilmed or.
Yeah. That's just the way the present statute is, but
Well, it also has provisions for, if they have no administrative, fiscal, historic, or legal value.
that'd be
Now,
correct.
That's a subjective determination, I guess.
Well, actually, it's determined by statute and 42.1-82, the Library of Virginia standards as it relates.
Yeah, I think Senator Sturtevant has a question. Wants to know how careful they're going to be.
Mr. Chairman, just having been a law clerk and gone through, these files can get pretty thick at times. And my concern, I wonder if it's been discussed or addressed, is, if a piece of paper is two-sided and only one side gets scanned, if there's sometimes small notes that may not get scanned into the electronic record that is saved, if you have appeal issues or habeas issues and the hard copy is gone, that would be that gives me some pause as to being able to immediately destroy it. Is that something that you all feel like has been addressed?
Mr. Chairman, Senator Sturtevant, we're talking about district court records, and we're talking about records that are going to be destroyed after the cases are concluded. So, I think that addresses the issue we're talking about.
Okay.
So, Mr. Chairman?
Senator Edwards.
This is only district court.
This is only district court. I'm sorry if I didn't say that.
All right. Any other questions? Anybody in opposition to this bill? Bill's before us. It's been moved and seconded the bill be reported. Clerk will open the roll.
Thank you, Mr. Chair.
Thank you. Sorry to keep you waiting. Appreciate your patience. Next, we've got Delegate Mullen. Good to see you.
Good to see you as well, Mr. Chairman. Thank you for the opportunity to be here. I think I have 3 bills up before you today. Not sure if that's a lucky number or not.
Well, I don't know. We'll see.
Can we start with House Bill 202?
202.
Just go from lowest to highest. So House Bill 202 gives explicit instructions by a judge that you have a community service option available to you to be able to utilize in lieu of your costs and fees. What I've noticed, particularly in district courts, is that we end up moving so quickly. We might have 100, 150 things on the docket, and people are not aware that their costs and fees, particularly for things like driving unsuspended or no operator's license, is something that they can utilize for community service. And so you end up with people who end up in a cycle of incarceration when they could have paid off their court costs and fees, or perhaps even gotten the opportunity to be able to get their driver's license again if they'd just done that work. And so this would just build on the work of so many in this committee from a few years ago in making that opportunity by just making it explicit.
So, I mean, this provides that the court is required to inform every defendant of that opportunity, right?
Yes, that's correct.
How precisely does that happen? I mean, is a judge
it's not
is it on the judge's form or
So
what?
it could be part of the judge's form, or it could be part of the instructions that the court clerk gives, or it could be an explicit statement of the judge from the bench. But there needs to be an explicit statement so that it's not just one of those things gets forgotten.
Mr. Chairman?
Sarah Edwards.
Yeah, okay, how much what credit do you get for an hour?
$7.25 is usually what you get, minimum wage.
There's nothing in here that says that. Is there?
So, there are some courts that will give higher than minimum wage. I know of no courts in the Commonwealth that give lower. But, I think it is discretionary to the judge and to the court. It's usually set by local practice as to what the amount is.
Mr. Chairman, shouldn't there be some kind of standard?
I certainly have no problem with there being a standard. That wasn't the intent of the bill as it was, just to give notice to people. That was sort of a separate policy decision that had been made by members of this chamber and the House.
Do you have any idea how many courts in Virginia are giving notice?
I can tell you that I regularly practice in 5, and I would say that probably 3 out of the 5 of them are not regularly giving notice.
Have you asked the clerks if they would? Or
They
the
always say,
judge?
I've spoken to them, they all just say they're busy.
And can't you?
As a Commonwealth?
Yeah, sure.
I guess I could, but that's not part of the only requirement of my job, and particularly since there are many cases in which the Commonwealth is not involved, particularly in traffic court or in district court on misdemeanors, that
So we just heard earlier about staffing issues in district court and you know, the difficulty in getting summonses
200
and
and some
complaints out.
positions that are open.
I mean, would you envision this being a burden falling to the clerks?
I think that this could fall either to the judiciary or to the clerks. I think that this could be in the form of a form, or this can be in, well.
In your experience, when we give that discretion, it all rolls downhill, doesn't it?
Well, as somebody who regularly practices in the district court, I can tell you it most certainly all rolls downhill.
Okay. All right. Anybody in the audience wish to speak in favor of this bill?
I move report.
Second.
Anybody wish to speak in opposition to the bill? All right, motion's been made to report. Clerk will open the roll.
Ayes 9, noes 4.
Okay.
Thank you, Mr. Chair.
Next.
Next, we have House Bill 1260. This deals with 4 additional crimes for which there would be a rebuttable presumption against bail. These are taking or detaining a person for the purposes of prostitution, receiving money or procuring or placing a person in a house of prostitution, receiving money from the earnings of a prostitute, or commercial sex trafficking where you have a family member. Actually, it's now at this point commercial sex trafficking generally. So these are the 4 crimes that have been identified by the Hampton Roads Human Trafficking Task Force that was set up over the course of the last year as being those most intrinsically linked with human trafficking. And the problem that we've seen is that someone might be arrested along with their, for lack of a better term, pimp, who ends up being bonded out by the person who has been continuing to perpetuate their human trafficking. And then they don't show up. They continue the cycle of abuse, and the thought is that you would be able to break that cycle of abuse by being able to maintain that those individuals who are charged with these 4 select crimes would be held under a rebuttable presumption. That is the essence of the bill. I'm happy to answer any additional questions.
All right. Any member of the committee have any questions? Let's hear from folks who wish to speak in favor of.
Good afternoon, Michael Newman, Commonwealth Attorney, City of Danville, here on behalf of VACA, and we do support this bill. Thank you.
All right. Anybody in opposition? The bill is
Mr. Chair.
before us.
Mr. Chair.
Senator Peterson.
And this may be a question for the Mr. Benjamin. What are the classes of crime for which we presume no bail right now? I mean, I see a listing of them here.
Mr. Chairman, it's kind of like the multi-jurisdictional grand jury. We started off with some really serious offenses and have generally been adding to them.
For the most part, it's violent offenses for the most part. We have added, and drug offenses.
Drug offenses. I might ask this question. Is it, in fact, do we know from experience that with the defendants in these particular crimes that we are having a problem with their returning to court?
So, yes, and in particular, the Hampton Roads Human Trafficking Task Force identified these 4 as being those that are most intrinsically linked with the pimp bringing the person that they have been trafficking out of jail and then scurrying them away.
And so, Mr. Chairman, we are not just identifying onerous offenses. You, in fact, have, in your experience, you've determined that the defendants in these categories of cases actually are a risk of
That's
flight.
correct. And so,
has anybody done or produced any quantitative data on that?
I can tell you that part of the reason that the Hampton Roads Human Trafficking Task Force was created was to put together some best practices for Commonwealth's attorneys' offices around Hampton Roads, as well as the Department of Homeland Security, victim service providers, and federal law enforcement. That was begun in November of 2016 in conjunction with the Attorney General's office.
But when I talk about quantitative data, following up on Mr. Benjamin's question about number of criminal defendants who do not show up for their court dates. Delegate, you have any? Mike?
The quick answer is even if the Attorney General's office were to say no.
Okay.
I'm Brittany Anderson with the Attorney General's office. We started the Hampton Roads Human Trafficking Task Force as a partnership, like Delegate Mullen said, with local, state, and federal law enforcement, Department of Homeland Security, with a grant that we received from the federal government. So we're happy to provide any quantitative data that we've gathered from that. Our grant is still fairly new, and we're still putting a lot of the reports together. So I think come this time next session, we'll have a lot more information that we're able to share.
And, I mean, I don't disagree that this seems like a good idea. But, you know, we see a lot of bills that seem like a good idea. And, you know, I wonder whether putting the cart before the horse and doing this before you generate the quantitative data that you're working on. And, I mean, we can do it now, or we can do it next year. It's up to the committee. But you're working on that, gathering that data, right?
Yes, sir. And I guess I can just add, you know, this was a request by some of the local prosecutors and local law enforcement that participate in the human trafficking task force. Okay. And one of the reasons that they did ask for us to bring this bill forward is because a lot of the times they have to take these cases federally, so that they don't have that option for bail if they fear somebody may become a victim. Yeah.
So, Mr. Chair, I will also say that I practice primarily in the Juvenile and Domestic Relations Court handling juvenile sex crimes. That's what I spend the majority of my time doing, and I have found that in cases in which we are having multi-defendant human trafficking cases, I will almost to a rule request that they go federally, because the individual crimes themselves would not be ones that I could hold them on in local state courts, but the feds can. And so this would be able to allow me to be able to prosecute better on the state level, as opposed to having to ask an assistant United States attorney on their already full docket to be able to take some of those cases.
Mr. Chairman?
Sir Edwards.
In the federal system, are they holding them without bail?
That's correct.
Mr. Chair.
Sir Deeds.
Judge Billy Moore started this Christmas tree in about 1996 or 97, and I wish we chopped it down and never let it flourish. But it seems to me that these crimes certainly they belong on the tree if the tree's going to exist. So unless we're willing to chop the tree down, I move to report the bill.
Can I ask just one more question before we report? I mean, the crimes that we're talking about these are prostitution crimes, or are they?
These are not all prostitution crimes.
So it's, for example, taken across a state line with an immoral purpose? I mean, like a Mann Act or what?
No, this is not a Mann Act thing. So commercial sex trafficking is one of them. That is the closest that would be applicable to the Mann Act. But the others are taking or detaining somebody for an unlawful purpose. So that could be restraining somebody in an automobile or bringing them into a home. So those are most directly related to keeping what, I hate this term, but it's in the code, bawdy house of prostitution. So, I mean, the place that you would know on the block where you could go and find a prostitute. So that's what these are primarily related to.
Okay, final further question. So, for example, up in my area, you get massage parlors, okay? Would it be somebody, for example, that operates or owns a massage parlor?
Senator, I would say that outside of like the Route 1 corridor that you have up near your district, Hampton Roads has more of those illegal massage parlors than just about any place on the East Coast.
And that is what this statute would?
That is exactly what this would be focused on, because in those instances, and I have this on a regular basis, you'll have people who have been sex trafficked from Southeast Asia who are brought in from New York on a 6-month basis, and then they are rotated through, for lack of a better term, between different massage parlors in different cities. And so if they are released on bond, the first thing that will happen is they'll be sent back up to New York or to a different city, and we'll never see them again. And so we won't be able to shut down those illegal massage parlors, which are really houses of prostitution.
Okay. Any other questions? Sarah Lucas.
I'm sorry, how many regional task force on human trafficking are there in the state? Maybe because I'm hearing a lot of talk about Hampton Roads.
Honestly, I don't know the answer to that.
So Northern Virginia has a regional task force, but I think it might be a little different than our Hampton Roads Human Trafficking Task Force. We put the task force together with a partnership with local and state and federal law enforcement because Hampton Roads was identified as a major hub of human trafficking. And that's what our grant is allowing us to do, is form these partnerships, but also gather this data from these cases and from these victim services providers to be able to determine, what are the what's the best path forward to address this in this particular area.
Any other questions? There's been a motion to report. Is there a second? All right, it's been moved and seconded. Clerk will open the roll. All right. And your third bill.
Thank you, Mr. Chair. I have House Bill 1511. And before we move forward, I believe that as a result of a line amendment that staff has, there is now peace in the valley on this.
Charles?
Mr. Chairman, the amendment is on line 21 after duties. You would insert, provided that the sheriff in the jurisdiction where process is to be served has agreed that such investigator may serve process.
So,
all right, is there a motion on that amendment? You want to explain what that amendment does?
yes, so Mr. Chair, what this bill does is it fixes the problem that allows investigators for the Commonwealth to be able to serve process for witnesses. They are already allowed to serve every other type of process. What this line amendment does is just make sure that they're not encroaching on a sheriff's prerogatives and allows them to do it only as long as the sheriff agrees.
Okay, is there a motion on the amendment? Is there a second on the amendment? Second. All right, the amendment's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? All right, the amendment's adopted. Steve?
Mr. Chairman, it would make sense to me, and the bill does make sense, that if we are extending this to investigators employed by attorneys for the Commonwealth, that it also include investigators who are employed by the Indigent Defense Commission. In other
I have
words,
zero disagreement with that. I mean, as long as they fulfill the same requirements of prior law enforcement so that we understand that they're not just somebody who's randomly off the street.
I move that amendment.
and what we would do is on line 17, after the word Commonwealth, insert the words or employed by the Indigent Defense Commission.
As long as we're not making any changes to the.
We're not.
All right, let's just double check. Commonwealth's attorneys, you okay with that?
Mr. Chairman, Darrell W. Puckett, Commonwealth's Attorney for Appomattox County. I'm here representing the Virginia Association of Commonwealth's Attorneys. We were in favor of the bill as it originally stood. In the spirit of compromise, we support the amendment with regards to the sheriffs.
How about the Indigent Defense? Surely you don't object to that.
I don't object. Maria Jankowski on behalf of the Virginia Indigent Defense Commission. Not having seen the amendment, I'm a little concerned about the sheriff granting the permission to the prosecutor and not to the public defender. I think that in light of that amendment, it could put us almost at a disadvantage. But I agree with Mr. Benjamin's representation. I think he's 100% accurate. Not having seen it, now I'm concerned about that.
I tell you what, just given the ambiguity, why don't we take this by for a couple of minutes and let you all huddle, because I think it seems to be broad agreement in principle. Mr. Jones? Yeah. And maybe you can huddle with counsel, and without objection, we'll pass this by temporarily.
Thank you, Mr. Chair.
And we'll come back to it today.
I think we can figure it out.
All right, next we've got Delia Fowler. You get some continuing legal education credit for sitting through this.
Yes, I
or
really
something.
appreciate that, and I can use all the education that I can get and that y'all can muster. Anyway, thank you, Mr. Chairman.
151.
Yes, House Bill 151. I believe we have a line amendment.
We do, Mr. Chairman. On line 40, we would strike after qualified the remainder of line 40 through B on line 41, and then we would insert by training as established by the Criminal Justice Services Board.
And, all right, give that to me slowly again.
Sure. On line 40, after qualified, strike the remainder of line 40 through B on line 41, and then we insert by training as established by the Criminal Justice Services Board.
Okay. All right, is there a motion on that amendment? It's been moved and seconded. All in favor of that amendment signify by saying aye. 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 All opposed, that amendment's adopted. Go ahead.
All right, thank you, Mr. Chairman. House Bill 151 clarifies basically the authority and jurisdiction of special conservators of the peace. The bill requires that the order of appointment shall provide that the special conservator of the peace can perform only those duties for which he or she is qualified by training. Secondly, the order shall provide that such duties shall be exercised only within such geographical limitations as specified by the court and are only applicable when engaged in the performance of his or her duties. Finally, let me see, and it goes on, line 64, I believe, that deletes language that may authorize the use of seals of the Commonwealth on a badge or other credential or on the uniform, and also prohibits displaying or using the word police on any uniform, badge, credential, or vehicle in the performance of his or her duties, except for special conservators employed by a state agency. And lastly, Mr. Chairman, I believe it's around line 188, that the legislation provides some discretion in the order of appointment for special conservators of the peace employed by the Shenandoah Valley Regional Airport Commission, the Regional Metropolitan Transportation Authority, and the Museum of Fine Arts, which again are all basically public bodies. And again, Mr. Chairman, this bill is supported by the Virginia Sheriff's Association, the Virginia Association of Chiefs of Police, who are here, and I believe also DCGS, I believe, is here to speak in favor of the bill.
Well, and maybe you or one of the proponents can answer this. I mean, can you tell me, what is it that you're trying to address with this?
Well, again, I think, we're just basically to clarify the authority and what the authorities of special conservatives are and exactly what their geographical jurisdiction is. And again, I'll defer to Mr. Jones.
All right. Mr. Jones, welcome.
Mr. Chairman, I'm John Jones representing the sheriffs. This is a bill about authenticity. All it does is clarify that if you're going to have police, you will be a policeman. If you're going to have a badge that says you're a police officer, you will be one. Currently, the SCOPs have police on the vehicle, on the back of it. They have badges that say they're police. The Commonwealth seal is on the badge, but they are not trained and they're not police officers. So this clarifies that if they're going to be out, well, whoever has police on it will have to be a law enforcement officer. So it's about you are who you say you are. And the carve-outs, we're all in favor of that. These are public entities. One is the sheriff of Augusta County working with the airport, and he uses those folks to help secure the airport. And he knows what's going on if we've asked for the carve-outs.
All right.
Hope you'll pass the bill.
All right. Anybody else will speak in favor of the bill?
Good afternoon, Mr. Chairman, members of the committee. My name is Kevin Carroll. I'm the president for Fraternal Order of Police of Virginia. We support the legislation. Thank you.
All right. Thank you. Anybody else?
We got DCGS.
Good morning, Mr. Chairman. My name is Thomas Fitzpatrick at DCJS. The administration does support this bill, especially as it was originally introduced by Delegate Fowler. With regards to the carve-outs that he did explain.
I mean, we haven't messed it up with our amendment, have we?
No, the amendment that Mr. Guglielmo read was fine. It's actually the carve-outs with regards to the Shenandoah Airport, RMTA, and VMFA. The administration is still looking into those carve-outs, has to speak with the stakeholders to better understand the reasoning behind those carve-outs. So we don't have a position on the carve-outs. We do support the underlying bill itself, though, and we're going to be having conversations with them. I've already spoken with them as well earlier today.
I mean, you do understand why somebody at an airport might want to hold themselves out as police, don't you?
The administration is still looking into those three carve-outs. I think that I understand your question, and I've addressed that with
All right, thanks. All right, anybody else? Anybody in opposition to the bill?
Mr. Chairman. Senator Riggs.
Yeah, okay, go ahead.
Mr. Chairman, I'm just going to make a statement that.
You want to hear from opposition
absolutely.
first?
That's
okay.
fine.
Yes, sir.
Thank you, Mr. Chairman. My name is James St. John. I'm the Director of Special Projects with a company called Golden Seal Enterprises. We're a private security services company out of Winchester, Virginia. I happen to be an SCOP. We have roughly 7 SCOPs on our staff. To address the issue of training, I'd just like to let you know that one of our SCOPs is a founding member of SEAL Team 6. We have a former FPS officer who was also in the Marine Corps and retired from the Marine Corps. We have another officer who was in the Marine Corps, did embassy security for 25 years. And as a private security services company, we can get sued just like any other entity. And so when we send people out in the field, we don't send them out without adequate training. The 2 most common lawsuits that we would face would be failure to supervise and failure to train. So we consequently make sure that all our officers are trained basically to a standard that's going to allow them to do what they have to do. The current requirements for SCOP training are woefully inadequate. We supported the increase in training to 130 hours. And of course, that's still much less than a municipal or county police officer would receive or a deputy sheriff. But what I'd like to emphasize for you is that the SCOP is a limited function officer who enforces the laws of the Commonwealth. And so what that means is we keep the peace and we protect property. Generally speaking, we do not do broad law enforcement. And so consequently, we don't need to be trained to the level of a municipal police officer. Part of the reasons why the program exists is because sending someone through a full law enforcement academy is pretty costly. You have to pay the person to go. You have to pay for the education itself. And usually the things that we do are so limited in scope that we wouldn't need that level of training. And there's a lot of municipalities, and it's interesting, I find year after year they never show up here to say, hey, we use these people for code enforcement, and we really like you not to continue to increase the training requirements. Another thing some of you, I'm certain, are aware of is that there were 2 year-long task forces on this just a couple of years ago. The Virginia State Crime Commission looked into these issues in detail, and they rejected the amendments that are being put forward right now. They were discussed, they were completely thought through with subject matter experts, and they rejected that. And what we have here now is the Sheriff's Association, a couple sheriffs here saying, look, we'd really like to clean this up. The thing is, the experts have already looked at this. The people who do this for a living have already weighed in on this. The lawyers have weighed in on this. You have on your committee an attorney who has worked in substantial detail on one of these bills. So these aren't the subject matter experts coming forward and asking you to make a change. These are a couple of sheriffs and some lobbying organizations for law enforcement officers who are asking you to basically give them a monopoly on the word of the use police. And I sympathize with them, and consequently I've offered to Delegate Fowler a compromise that would basically require all SCOPs to have the word SCOP or Special Conservator of the Peace or Conservator of the Peace alongside the use of the word police so that nobody would get confused about that.
Okay.
Because we sympathize.
Yeah, and I appreciate it. We neglected to turn the clock on, but I appreciate your comments. If you can wrap up, I'd be grateful.
Thank you, Mr. Chairman. Consequently, we would ask, this bill, we do sympathize with the proponents, but we would ask that you basically put this bill aside for this year, or at least for enough time to allow us to try to make some compromises here and make this bill so that the legal language in it makes sense and works for everybody, because quite frankly, it's just not ready yet.
All right.
Thank you, Mr. Chairman.
All right, Senator Reeves.
Mr. Chairman, I think the last speaker at the podium probably conveyed my thoughts, because I was on the Crime Commission and helped work on SCOPs and thought we had included all these things. And, Mr. Chairman, it really irritates the tar out of me that we're asking for an exception right after getting all this done when there could have been an opportunity at that time. We made exceptions for certain policing agencies, and I think there were 7 or 9, if memory serves, somewhere in there that we made those exceptions for and said that was it, we were going to close the door. Now, I do understand that this is a public service organization, or whatever you want to call them, SCOPs, but Mr. Chairman, for that reason, I'm going to vote a no.
Okay. Anybody else? Bills before us. All right, it's been moved to report. Is there a second?
Second.
All right, it's been moved and seconded. Clerk will open the roll.
Ayes 10, noes 3.
All right,
Thank you, Mr. Chairman, members of the committee.
thank you.
Thank you.
Next, we've got Delia Davis. Delia Mullen, you ready? Come on.
I defer to him, he's been waiting longer. It'll be quick, thank you.
I hope
At least
so.
I hope so.
You think?
Well, I'm hoping I qualify for having read the law after this meeting.
Maybe
So-
Senator Peterson begs to differ.
Well-
It's going to be quick.
Probably not.
Okay, let me,
All right,
let's
get
we'll finish up then.
Delegate Mullen up.
I apologize, I didn't mean to snake in front of him. I believe that we have some language now with staff that would, in essence, say that a sheriff would be able to either approve indigent defense counsel and Commonwealth's attorneys, or not. So you got.
All right,
We're
we're going to report the.
There you go. All right.
What do you mean not, Mr. Chairman?
I see great peace among our warring factions.
Senator,
I hear ambiguity. What?
The concern was that a sheriff would approve the authority for the Commonwealth's attorney, but not for the public defender.
Okay,
And
that's-
the thought was that that was inherently unfair. And so if the sheriff is going to be allowed to approve anyone, they would have to approve both the Commonwealth's attorney and the public defender.
And I'm getting thumbs up from the sheriffs, right? From the indigent defense and from the Commonwealth's attorneys on this. So maybe council can report the amendment.
Mr. Chairman, after the amendment that the committee has already approved, there would be a period, and then there would be a standalone sentence that would read as follows. Such an agreement shall be deemed an agreement that investigators employed by both an attorney for the Commonwealth and the Indigent Defense Commission may serve process.
So it's both or neither?
That's correct.
Okay. Any questions?
Mr.
Anybody? Senator Peterson.
Yeah, my question is broader. This is a code section applicable to all civil process, correct?
It is.
Why are we changing it for this sort of particular situation?
Because there's about, I think, 15 of the 120 jurisdictions in the state that have investigators for the Commonwealth or investigators for the public defender's offices who are employed not by the sheriff's department or on a part-time basis, but full-time employees for whom serving process when they go out to interview a witness. So you go out to interview a witness in my case, a sexual assault case.
Right.
You might only actually interview them once or twice because they don't want to talk to you. And so when you do, that same person who's doing the interview can also say, and by the way, you now need to show up in court. And so you don't have to have a second person come through and serve them with a process by a posting on their.
Okay, call me crazy, but isn't the whole purpose behind process to have an unbiased person that actually serves the papers?
So the rule that says that somebody would be conflicted would not apply to the entirety of the office. It would only apply to the individual. But if that person were to be a witness, the Commonwealth or the Indigent Defense Counsel would have to take that into account because otherwise they could be inapplicable to testify as a witness. You're
And again,
absolutely right.
I'm just, if I might,
Senator
I'm a
Peterson,
very
go ahead.
simple guy here, but my
I know.
understanding of service of process is that you want someone who will serve process and file an affidavit of service who does not have an interest in the case.
Well, I would say that the sheriff's department sometimes has interests in cases when they're the primary investigatory agency within a particular jurisdiction. They're the law enforcement. And in most jurisdictions, unlike Fairfax or where I am in Newport News, don't have a police department. They have the sheriff. And the sheriff holds those two dual functions.
Yeah, my sheriff's office has investigators and the works.
Okay, all
All
right.
of the sheriff's offices I represent.
Like I said, I'm just.
All right, bills before us. All right, I guess the amendment is before us. Is there a motion on the amendment? Second. All in favor of the amendment signify by saying aye. Aye. All opposed?
Move the report.
All right, there's motion, a report properly seconded. All in, clerk will open the roll. All right, bill reports. Thank you very much.
Thank you, Mr. Chair.
Appreciate it. Delegate Davis.
All right. Thank you, Mr. Chairman.
House Bill 1351 is just a bill that would ensure that the courts, when dealing in child custody cases, consider if joint legal or joint fiscal custody would be appropriate and in the best interest of the child without impacting any of the presumption. So,
Mr. Chair, Mr. Chair, doesn't the court already do that?
So Mr. Chairman, actually, right now, as specified out in the code, it does, and it actually looks at that. It prevents presumption when choosing between the two parents, and specifies looking at both those. But it actually does not dictate that when it comes to the primary consideration, that part of that primary consideration has to be joint legal or fiscal custody, and that's all this bill does, to specify that.
Well, Mr. Chair.
Senator Deeds.
It does, at this point, the code only requires requires that the court consider the children's best interest.
Yes, sir.
Paramount, and this adds another thing, says, yes, best interests are paramount, but you also need to consider joint legal or physical custody.
Well, Mr. Chairman, I would say that right now it says that when looking at what is in the best interest of the child, it basically says that it could be either parent. Neither one has presumption. What this does is clarify and say that when you're looking at the best interest of the child, you must also consider whether joint fiscal custody would also be in the best interest. Right now, that is not mandated.
To put a finer point on Senator Deeds' question, I mean, and I'm not a family law practitioner.
Sure.
So I've never litigated this issue, and I see a couple of folks back here who probably can offer a little bit of insight. But when I read this, it says, shall give primary consideration to the best interest of the child, period. I mean, I always thought that was the primary consideration. And the reason it says primary consideration is because that's it. And what you're adding is, you know, a second primary consideration. I mean, I'm just having a hard time getting my head around that.
Well, Mr. Chairman, I would say that it doesn't add a secondary primary consideration. It just says that during deliberation of that primary consideration being what is in the best interest of the child, that the court shall weigh whether that could be joint fiscal custody. That's all it's saying. It doesn't add another layer of primary consideration. It just adds what is involved in that primary consideration.
Okay. Well, I tell you what, let's hear from those who love the idea.
Yes. Mr. Chair, and I hate to break in, but I have an amendment to this, which is.
I suspect your amendment is, let's address the issue, the patrons issue, and I have some idea as to what your amendment addresses, and we'll come back to that. Okay? Yeah.
Mr. Chairman, members of the committee, my name is Dan Gray. I'm here on behalf of the Virginia Family Law Coalition. We support the bill that was passed in the House. You know, we were, the original sort of concept we were lukewarm on, but in the spirit of compromise, we worked with the delegate and we agreed on this language, and we think that it's not problematic, so we support it.
Mr. Chairman?
Sarah Edwards.
Is this part of the Virginia Bar Association or what?
It's the Virginia Bar Association's Family Law Coalition. Okay. It's a group of practicing family law attorneys.
Mr. Chairman, judges tell me joint legal is one thing. Joint physical is very problematic. A child needs a place and not be flipped back and forth every other day or every other week even. Would you agree with that?
Well, on a personal level, I think that every case is different, Senator. And I think that this does not mandate that the court order shared physical custody. What it says is that the court, in considering the best interests, ought to look at the issue of shared physical custody as a possibility. And I think what the delegate was speaking about earlier was that it's not entirely clear that that should be a consideration.
Well, Mr. Chairman, don't judges often, one side or the others, argues that.
Absolutely.
And so it's before the court. And why would we want to mandate that a juvenile judge, for example, must consider the primary consideration is the best interest of the child, and also a primary consideration is joint physical custody when they tell me it doesn't work very well?
Well, I think that there are differences among judges and differences among litigants. And I think, again, what this language proposes is that you can certainly reject that as a possibility if you care to, but it's something you ought to look at when you're determining custody.
Well, Mr. Chairman, you're telling me they don't?
I can't say. I can say that years ago, I think it was less a consideration than it is now. But I think that this is intended to address the fact that perhaps some judges don't.
I just worry that, I mean, we're creating a Christmas tree of primary consideration. I mean, next year somebody's going to come and say, whether the custodial parent has insurance, the school district. I mean, are we really? Are we trying to put a list of what is in the best interest of the child, or are we supposed to be saying we want our judges to use discretion?
Mr.
Kristen?
Chairman, I would note that there is an entire section of the code that lays out a list of what the court is to consider with the best interest of the child. That is in 20-124.3. And then there's a catch-all at the end, such other factors that the court deems necessary and proper to the determination, which would include whether joint or legal physical custody was appropriate.
So why put it here?
I'll defer to the delegate.
Well, you're the family law practitioner.
Well, I'm in a bit of an awkward position on this, Mr. Chairman. The coalition, again, we worked with a delegate and fashioned some language that we could live with, and I hesitate to speak against the bill, but I.
No, I understand, but you're the guy who's going to go to court, and you ought to be standing here being a defender of the family law code, and we want to make sure that we get it right, that judges have clear guidance, and that we don't muddy it up. And I appreciate the Family Law Coalition's advice, but it's no good if we don't have you all coming in here and standing up and dispassionately saying this is consistent with the spirit of the code, or this is well-intentioned but not a good idea. I mean, I love Delegate Davis, but I don't want to screw up the code, especially in an area I don't practice in.
Mr. Chairman, your concern is well taken, and I can tell you that the code states that the court may award primary physical custody to either parent. The court may award shared physical custody to either parent, primary legal custody, shared legal custody. The code already says you can do that, but it doesn't say that in this section. And I think the intent behind it was to signal to the courts that you all ought to consider shared legal custody as a practitioner.
But didn't counsel just cite the statute that says what are the considerations that the court is to look at in determining what is in the best interest of the child?
Counsel did indeed cite the correct section and the enumerated factors therein. I cannot argue with that.
I mean, isn't that the right place for it?
Well, it is in that same 2124.2 is the best interest statute. And within that statute, it lists all the factors the court must consider when determining best interests. And then there's a catch-all at the very end that says such other factors as the court thinks is important. This is included in that same code provision, and it just says, look, as you're determining best interest, you ought to think about whether shared physical custody is in the best interest of the children. And again, we did not object to that language going into this section of the code, but if you're looking for a ringing endorsement, I don't think the coalition can
Mr.
offer
Chair,
that.
would you then object to incorporating that whole code section into this statute?
The code section that references that the court may award.
The best interest code section.
I don't.
Would that serve any valid purpose? I mean, what purpose does this language serve in this section?
Well, as I said, I believe the proponents believe that it signals to the court that you should consider this.
But I don't think we're asking you in the proponent's
Mr. Chair,
intention is.
If I may answer, Mr. Chairman, if I can, because this actually started out inside the code that we're talking about. It actually started out in the 124.3 is where we were looking at actually putting this initially, Mr. Chairman. And the reason why is you can go through this code section, and unless I'm missing something, like I said, I do not practice law. I do telecom, which is completely different. But I could not find, in this code, it actually talks about how presumption should not be given to either parent. And it goes through, I'm looking at 10 things that talk about what can be taken into account. Mr. Chairman, I would say that one of those 10 things is not a mandatory look at joint, shared, or legal custody, or physical legal custody. So we initially were looking at putting this in this section of code. It was suggested to put it in 124.2, up where it talks about the primary consideration being the best interest of the child. And it notates there that part of that consideration shall be whether it's joint, shared, or physical custody, legal or physical custody, would be in the best interest. If this is someplace else in the code, I would be more than happy to pull this. I just can't find it, and the reason why this is in there was no one could find it. So it doesn't give presumption. It just, the way I read this code was it always talked about one parent versus another when it came to consideration, but never mandated a consideration of shared legal custody, Mr. Chairman.
All right. Let's hear from others. And we're way over time. I know you support it.
Yes, Mr. Chairman, thank you. And to that point, while there may be references to it in other parts of the code. I'm sorry. Yeah, thank you, Mr. Chairman. My apologies. Christian Posh with the National Parents Organization in Virginia. I lead their Virginia chapter. We're an organization of both women and men who advocate for preserving the bond between parents and children in Virginia, and we support House Bill 1351, along with the Children's Rights Council, Family Foundation, and individual family law attorneys for several reasons. I will say, pursuant to the conversation we've had here today, while the existing code may reference it here and there, reality is that the vast majority of the time, sole or primary custody is awarded, and 40-plus empirical peer-reviewed studies by the American Psychological Association, Association of Family Conciliatory Courts, and others all emphatically state that shared custody in the vast majority of circumstances is best for children. But that's not happening in Virginia right now. So this bill, which again has been vetted by and coordinated with the Family Law Coalition, simply seeks to emphasize that and asks the court to simply consider whether it's appropriate. And again, the location of it in the .2 section is based on a collaboration with the Family Law Coalition and others on the House side. The important things to remember here, too, is that it benefits our children.
I hate to do it. We're going to have to get you to wrap up.
Absolutely. My closing points here would be this bill provides a flexible option for the courts while still retaining judicial discretion. It actually can improve child support collection rates, which I'm happy to talk about if you'd like me to. It still protects victims of domestic violence. It does not touch the existing statutes in place to protect those victims. And finally, I will say that I'm one of the lucky ones. I could afford to hire an attorney, go to court, fight for my children. Candidly speaking, it took me over 8 years, 4 states. It's Partridge in a Pear Tree song here. But the point is I'm one of the lucky ones that could afford to do this. But that's not why I'm here today. I'm here today for all the other ones that can't afford to do this. And that's why we need to do this. So I thank you for your vote and voting for the future by voting yes.
All right, thanks. Yes, sir.
Josh Hetzer with the Family Foundation, and I just want to echo the same sentiments. We support the bill. Thanks.
All right, let me make a suggestion. Come on up. You like this or not?
Well, no, I just want to make something clear because of a comment you made, Mr. Chairman, and Mr. Davis is not a next-door neighbor, but we hail from Virginia Beach, and he may kick me at this point. I just want to give the committee some of the background here, and because you made a very good point, and I want to make it very clear that Virginia Family Law Coalition has always, and that they and the VBA are always, their first and foremost obligation is to be true to the law, to be true to the spirit of the law, and to advocate for the spirit of the law. In that vein, I want the committee to know, initially the coalition was opposed to Mr. Davis's bill. We worked with Mr. Davis because we do not feel that a presumption and locking judges in with any type of presumption of some sort of custody is in the best interest of children or in the best interest of the law. We worked with Mr. Davis to this compromise in a hope that this might clarify the situation.
Let me ask you this, and I don't have the history, all of the history in front of me. But you hear the concern that's been expressed about putting this here in 124.2, essentially muddying the water as to the primary responsibility of the court. Would the Family Law Coalition, and I'm not talking about the original version of the bill, but simply would they object to moving that language to 124.3 and listing it as one, just as here, one of the considerations that the court takes in conjunction with its determination of the best interest of the child?
And now, Mr. Gray may kick me because I'm kind of out on my own, or Ms. Evely may come. I don't know that the coalition discussed that, but I think it muddies the waters even more for practitioners to put it in 20-124.3. This is me speaking as a practitioner. Because the court, the law says, and the courts have ruled that the judge has to make certain findings along those. And while I think philosophically I don't have necessarily a problem with the judge being able to opine, I've considered these options, this is why I don't want to do it or why I do want to do it.
Well, I tell you, I will, I'll share with you my view. I do not think it belongs here in 124.2, and I would oppose that. I would consider putting it in 124.3 or supporting that. I mean, obviously, it's committee's judgment, but I think it's important to make that policy statement that the primary consideration is the best interest of the child. And primary consideration means primary consideration, not a Christmas tree. Right. So, I just would oppose that. And I don't hear a great alternative in light of some of the concerns expressed.
Mr. Chairman, would it be viable at this point, given that suggestion, and obviously not wanting to do anything on the fly, to pass by for the day to see if that gets worked out, or?
No, we got a minute for you to step aside and work on it.
Okay.
But and see if Family Law Coalition likes anything else. But I'd like to move on this today, and I know that Senator Peterson has an ancillary issue that he wants to bring up in conjunction with your bill.
Yes, sir.
Can I briefly speak to that, Mr. Chair?
Yeah, let's do that.
We have a situation which is unique in Fairfax County, a child that came to the United States on an asylum petition and is here legally is part of a custody dispute where the child would be sent back to a country that does not recognize the Hague Convention, so the child would theoretically at that point be gone. And the folks I'm working with, I see the gentleman here in the back had proposed an amendment which Delegate Davis very generously offered to make part of his bill since it's written to the same code section. I understand all the potential objections on germaneness and everything else, but it is the same code section. It would be, again, dealing with the best interests of the child. In this case, allowing a child that's here on an asylum petition to not be sent back to a country that does not recognize our custody laws.
Well, let me, just as a preliminary matter, and I know somebody came down here to testify to this, and I won't deprive them of that opportunity, but Delegate Davis, I mean, is this an amendment that you willingly accept to your bill?
Yes, sir. So my position on this, and this is not my bill, this is the two organizations that you've heard from. This is obviously something that concerns us all as humans. I'm not an attorney. I would not want to do anything that would do harm to this bill. I don't think anyone else would. There were a number of issues that were raised with the first set of amendments that came from germaneness on down. Another amendment came forward earlier today, which I understand have the same concern. So I would not want to do anything that has harmed this bill. I know it's up to this body to decide, but I don't feel that this necessarily fits from what I'm being told by the entities that I've spoken with, Mr. Chairman, but I do understand it's up to you all.
All right. Sir Peterson, do you have an amendment?
I do have an amendment. I could have it
in the
distributed.
nature of a substitute?
I think it is, and it's just a one paragraph added to 20-124.2, and I did have a witness, Mr. Chair, who's come down from Fairfax.
All right. Senator Peterson moves. Senator Deeds seconds the adoption of the amendment in the nature of a substitute. All in favor signify by saying aye.
Aye.
All opposed. note your nose, the amendment in the nature of a substitute is before us.
And,
All right,
Mr.
let's-
Chair, the operative language would be on the last page. It's basically 4 lines talking about the asylum issue. And like I said, I do have a witness here.
All right. Where,
They're looking at the language.
all right. Yeah, having, okay. Let me just say, having voted on the prevailing side by which we adopted the amendment, I move that we can, or the substitute, I move that we reconsider that
Right,
vote.
that's fine,
Any objection to unwinding that and going
No,
back?
absolutely not.
All right. So Senator Peterson's amendment is before us for consideration. So step up. Yes, sir.
Give the background.
All right, yeah, my name is John Foote. I work with Baker McKenzie Law Firm and a resident of Arlington County. Senator Peterson's amendment presents the committee with a very narrow question, which is, should there be a law, do you believe that there should be a law of the Commonwealth which says that if you have a minor child who has been granted asylum in the United States, that they should not be sent back to the country where they were granted protection from in the course of an ordinary run-of-the-mill custody or visitation case? And you may ask whether we need this law, and I'm here to tell you that, assure you that the answer to that question is yes, we do need this law, because there is no law of the Commonwealth that would presently prohibit a judge from sending a child asylee back to the country where they sought protection from. And by virtue of my extensive involvement in a pro bono case, matter arising in Virginia, I can verify that this is in fact a matter of urgent need. So, you know, a bill taken up at a later time will in fact be too late. So as you consider this amendment, I suspect you may have 3 questions in your minds. First, does anyone have any concerns or opposition about the substance of the amendment? And I suggest to you that as you hear different perspectives and concerns about the bill and the amendment, that I don't believe you will hear a single substantive concern about the nature of this particular amendment that Senator Peterson has put forth. There was an earlier version of the amendment that dealt with the Hague Convention, and the Family Law Coalition raised some concerns about that, substantive concerns. We've stripped that out of the amendment at this point. So right now, it is just as you see right there in front of you, paragraph G, which says that no court of the Commonwealth in a custody or visitation case may, dealing with a minor child who's been granted asylum, may order that that child or enforce an order that that child be sent back to the country that they were granted asylum from. So I urge you to consider that as different people have different opinions about what's happening with the bill. I don't believe you will hear a single substantive concern raised about adding that law to the code.
Let me, Mr. Chair, can I ask a question?
Please.
Sir, indeed.
I mean, if the paramount interest, the best interest of the child are the paramount concern, wouldn't it be better to say no court of the Commonwealth when you consider or no court of the Commonwealth in considering the best interests of the child, or a court of the Commonwealth in considering the best interests of the child may choose not to order or enforce an order? I mean, because it seems to me contra to the best interest of the child is a primary consideration.
Right.
If you're telling the court that it can't reunite a child with its parents, say.
Right. So, well, okay, so a couple thoughts. One is that in the case where you have a foreign order that's been registered here in Virginia, the best interest analysis is not the controlling factor in that type of a case. That type of a case comes up under the UCC JEA, which is in section 7.1 of Title 20. So it's a different section, and best interest analysis really doesn't hold the day in that type of a case. And then the second thing that I would say is that a court has this discretion. They have this ability to do it, right? And so the question is you know, does there need to be a rule that stands in the way? And the answer is, look, if a judge orders the departure of a person who's been granted asylum, a child who's been granted asylum, and that if that was to be appealed or challenged in court, if that's a discretionary determination, you have to show that the judge was abusing their discretion. And the question really then, I think, for the legislature is should this be a rule? Should there be a rule that says if the child has been granted asylum in the United States, as a matter of public policy in Virginia, the courts in Virginia don't send those children back to the country where they came from. So this would never be in a situation where you'd actually be preventing reunification with a family Rather, it's in fact about the opposite. It's about ensuring that the children don't get sent back to a country that they've been granted legal status and protection from.
All right.
If I may, just two other concerns that some of the members may have. So one is the substantive concern. Second is that I'll skip the partisan concern because I don't think there's concern about that. But the last thing is these sort of procedural and technical issues with regards to germaneness and with regards to germaneness. And what I would say in regards to germaneness is this amendment operates functionally the same way as the original bill. The original bill says that when a judge is making a custody determination, there is a specific thing that the judge must do. They need to consider whether joint physical or legal custody is appropriate. And this does the same thing in the same code of law, section of law.
Let me ask you this.
Yeah, please.
This arises from a case.
It does, in fact, yes.
What's the status of the case?
So the status of the case is.
Final order entered?
An order has been entered.
Final appeal over, done?
It is difficult for me to characterize that. I'm not counsel of record in any case involving
Case ongoing?
In this issue. Yes, there is ongoing litigation, and what is going on with respect to this issue will continue regardless of what the legislature decides to do with regards to this issue. So I mean, just to be completely transparent and completely candid, what you all are being asked to consider in the nature of this amendment will have no decisive impact on the litigation. Right. The question is
why do you say that?
Because there are other things that are at issue in the case of a visitation and custody case.
Well, and there have been a lot of phone calls being made about this, and if this is going to have no impact on the outcome of that case, why can't we take this up in the ordinary course of business next year when we come back, so we can do it deliberately rather than on the fly?
Right. Well, Mr. Chair, I would put a finer point on it. I won't say that what the legislature decides to do will have no impact whatsoever. In fact, we do hope that it will have an impact, which is to prevent children from being sent out of the country who've been granted asylum to a country where there's no way to ensure that they are returned. But the rest of the proceeding will continue on in regards to visitation and whatnot.
All right. Mr. Foote, thank you very much.
Thank you for your time.
Anybody wish to speak in opposition to this or express concerns about it? I mean, I don't know that anybody opposes what the proponent and Senator Peterson are trying to do. I mean,
well, first of all, Mr. Chairman, you correctly point out this matter is in active litigation. There are hearings coming up, and I do think that what is attempting to be done is to impact the result of that litigation. This matter has been pending in the Fairfax County Circuit Court. I spoke this morning with opposing counsel on the matter to find out what was going on. This is ongoing litigation. The mother in this case has been found in contempt by the Fairfax County Circuit Court, as I understand it. So this very much is intended to address a specific case that is currently pending in a specific circuit court. And as a matter of policy, the coalition is generally against supporting legislation that's intended to address a specific case, particularly one that's in active litigation right now. So we oppose it on those grounds. We also oppose it on the grounds that substantively the Virginia Code already provides for the considerations that are in this proposed amendment. Virginia has adopted the Uniform Child Custody Jurisdiction and Enforcement Act. And that act says when you have a foreign order that's been registered in Virginia, you are to give recognition to that foreign order unless the court makes a factual determination that the foreign country violates fundamental principles of human rights. So the trial judge is already given the discretion to not enforce that foreign order. And in this particular case, it's apparent, I don't know for certain, but it's apparent that the judge made a determination that it didn't violate fundamental human rights. So that's on that, and on the basis of germaneness, we also oppose it.
All right.
Mr. Chairman, just on behalf of the Virginia Bar Association, Richard Garrett, President-elect of the Bar Association, it's always been the VBA's position that any bill coming before the Assembly that restricts the latitude and ability of judges to act on a case-by-case basis is not in the best interest of the Commonwealth or the judiciary. And I just want to remind the committee of our position on that.
Mr. Chairman, I have a question. Yeah.
Yes, Senator
Senator Edwards.
I've been on the Board of Governors too, and chairman of criminal law section. And it's my understanding the Board of Governors, before a bill can come forth with as sponsored or is supported by the Virginia Bar Association, the Board of Governors have to approve it. Is
That's
that
correct,
right?
Judge.
And this has not happened in this case.
Well, as I said, we do not, as far as this amendment, we have not vetted this amendment to look at it.
Okay.
And my position at this point is what it seems to be happening is we're hamstringing our judges. And I don't think that's for the best interest of the judiciary.
Thank you.
All right.
Mr.
All
Chairman,
right,
I just say
here,
one word response.
no, we're not going to, the sit in court, we're not going back and forth. And Senator Peterson, you want to move this amendment?
I'll move the amendment.
All right. Is there a second?
Second.
All right. The amendment has been moved and seconded. Delegate Davis, you want to make any final comment about this amendment?
Mr. Chairman, I would just say that this whole bill has been about parental rights and making sure that that joint custody is looked at. That's what we want to hold dear to this. So I can appreciate this, but if this does harm to the bill, or for various reasons that this could open some other problems, I would not rather see this
Senator
amendment move
Chafin.
forward.
Mr. Chairman, this amendment, I mean, there are a number of reasons that I can't vote for the amendment. The first one is that it violates a longstanding policy of this committee, and that is to not take up matters where there's pending litigation. That's number one. But number two, I think that this amendment, there are all kinds of primacy issues here that exist with regard to parental rights, and there's a big constitutional issue here that we're just not talking about when we're telling the court that the court cannot rule in these instances. It's not talking about just enforcing a foreign order. It's talking about that the court can't rule a certain way, and we have all these factors that are already long-standing in effect under 20-104.3 that lay out the reasons that the court can rule. So I'm not able to support it.
All right. And, I mean, Senator Chafin is right with respect, and I think that you've talked to counsel, you've talked to many members of the committee, and we just, I've been on this committee for 16 years, and never, to the best of my knowledge, recollection, or belief, have we knowingly passed legislation dealing with any pending litigation. Never. So, it's not out of lack of sympathy or compassion that I would cast a no vote. So the motion is before us, properly seconded, to adopt the amendment in the nature of a substitute. This is to adopt Senator Peterson's substitute. All right, clerk will open the roll. All right.
Ayes 1, noes 13.
All right, delegate, have you
May we have
worked
just,
anything out, or?
maybe, yes, sir. May we just have a few minutes to pass it by temporarily?
We got a couple other patrons
Yes, sir.
patiently sitting in here. Delegate Reed.
Mr. Chairman, can I allow Chairman Ingram to go next?
You darn right. You're picking between those chairs, and you pick Delegate Chairman Ingram over Chairman Ware. I'm sure that Chairman Ware may take notice of that.
He's my chairman.
Mine is House Bill 1164. It's a bill that I'm carrying for the Speaker of the House, Kirk Cox. This bill was requested by the Colonial Heights Police Department. It would allow for search warrants to be returned in the jurisdiction where the warrant was executed rather than where it was issued.
Well, let me ask, I mean, it seems very straightforward. Council have any, is there any problem with this bill? Any objections or concerns about it?
No, Mr.
I'm not
Chairman.
aware of any.
It won't take, it's no opposition to it at all. It's,
All right, it's been moved and seconded that this fine bill be reported. Clerk will open the roll.
thank you.
All right. Next, you want to flip for it? Chairman Ware.
I'll defer to.
My leg is falling asleep over here. I have House Bill 162, which is about partition suits, and essentially it updates the dollar amount that hasn't been changed over the course of decades. I can read you.
We have a new expert on partitions on this committee, and we're going to defer all questioning to Senator Chafin. If he has no questions, I have none.
If he does, I can give him some.
This seems to make good sense in that
You all practice before the bar. This came from an attorney in Goochland who is also practices considerably in this area. And I can read you his rationale if you like.
Well, my recollection, and I deal with 801-606, which deals with small funds being administered without the intervention of a fiduciary. My understanding is that this treats partitions and partition-generated funds in the same way as other small funds and increases that limit from $4,000 or $4,500 to $25,000, just like
That's correct.
infant settlements, for example. So those lawyers dealing with those cases, I think, understand that. Anybody have any questions?
Move report.
Second.
All right, our expert on partitions seconds the motion to report. Clerk will open the roll.
Thank you, Mr. Chairman, members.
Thank you. All right. We'll see, Delegate Reed, if your good judgment is rewarded.
I sure hope so, Mr.
1219.
Chairman. So House Bill 1219 is also another one that I believe is a simple change. As the statute is currently written, the restoration statute is almost never used to actually restore parental rights. The intent here is to change this so that the court would be directed to make a simple inquiry of the guardian ad litem or the social worker and ask whether or not the child has requested that the parental rights be restored.
And this is in foster care situations.
This is in a foster care situation, yes, sir, Mr. Chairman.
And so in custody disputes between parents, they already have the, or they don't take into consideration the interests of the child. They do, don't they?
No, I'm not sure if they do or not, but it is not being addressed here. That is not being addressed here.
I understand, but it simply is saying in a foster care situation, we are going to take into consideration the desire of children over 14.
Yes, sir.
Or 14 and over.
And the intent here really is to make sure that we minimize the number of children that are orphaned as they age out.
Anybody have any concerns or questions about this bill? Anybody wish to speak, feel compelled to speak in favor of or in opposition to this bill? You like it? Or not?
Yes, Mr. Chair. I'm very much in support of this bill. Valerie LaRue from the Virginia Poverty Law Center. And the chair is exactly right. This would only apply to children who were in foster care whose parents' rights have been terminated. And the reason for the age 14 is because the termination statute allows children who are 14 and older to have a veto on whether the parents' rights. So it's giving them basically the same rights as the termination statute.
Okay. All right. It's been moved and seconded the bill be reported. Clerk will open the roll. All right. Well, congratulations.
Thank you, Mr. Chairman.
Is that
Thank
all?
you,
You've been
committee.
waiting for that. All right. And we've got Delegate Habib's House Bill 77, which is identical to Senator McDougal's Code Commission bill that reported out of this committee, but I don't think we got a hearing on it once it was re-referred.
Move report.
All right, it's been moved. Is there a second? It's been moved and seconded that House Bill 77 be reported. Clerk will open the roll. And do we have another Habib bill? One more. Which one? 780.
780.
Yeah. House Bill, I knew that sounded familiar. It's virtually identical to my Senate Bill 564, which passed out of here 15-0, but it had a fiscal impact, and my understanding is that that the House had an amendment that struck line 181 relating to adult cases in juvenile and domestic relations court, which I'm led to believe eliminates the fiscal impact of this bill. So I would suggest that we report this bill in the form that it came to from the House without amending it. All right, it's been moved and seconded. Clerk will open the roll. All right, and I guess we've got Delegate Davis. Are they done? They're not? All right, they're either gonna, I think we're gonna rise, and they're either gonna present something that we love on Monday, and or we're going to dispose of it with no further testimony. So the committee will rise.